Sitting to the other side.
Sitting to the other side of Jennifer. Can you?
Good evening. Welcome to the Costa Mesa Planning Commission meeting for August 12th. I will call the meeting to order and ask Commissioner Zick to lead us in the Pledge of Allegiance. Thank you, Commissioner Zick, very much. Julie, roll call, please.
Chair Dirical.
Here.
Vice Chair Harlan. Commissioner Colbert absent. Commissioner Navarro Woods. Here. Commissioner Russell.
Here.
Commissioner Torje absent. And Commissioner Zick.
Here. Thank you very much. We have no announcements or presentations tonight on the agenda, which brings us to public comments. To ensure fair and equal treatment of all who appear before the Planning Commission and to expedite city business, speakers may be limited to 3 minutes during public comments to speak on any item within the Planning Commission's jurisdiction which is not listed on the agenda tonight. This time may be extended for good cause by the chair or by a majority vote of the Planning Commission. Is there anyone wishing to speak during public comment tonight? Yes, ma'am. Good evening.
So public hearing number 1 is all about sober living. So I just want you to know that the residents of Costa Mesa now know the routine. We skipped the planning commission meeting because we hope that you will uphold the staff's recommendation, because you blindly follow the staff. You never listen to the residents. No offense, but something could have been done about this 10 years ago. Okay, so now we're at the stage we're at. So we know the routine, so we didn't bother to come tonight, but I'm letting you know why. So that we know that they will appeal it to the city council, and then hopefully the city council will uphold the ordinance, and then they'll sue us. And that's how it goes, and we know how it goes. And I want you to know that I sat in that courtroom almost every day last November, and at the end of that hearing, the judge said, he was surprised because he felt that our ordinance actually favored the operators. So actually, the residents of Costa Mesa are being discriminated against by our ordinance. So I don't get why all these people have been allowed to operate all these years. No one ever did anything until Katrina Foley became mayor, and I'm really upset about it. If you listen time after time after time, they've been running for 5 and 6 years, and nobody's done anything, no code enforcement, nothing. Okay.
Thank you. Anyone else? Yes, sir.
I don't know if we ought to speak about what's coming up on the agenda, but as the previous speaker mentioned, they're still operating, regardless. By the way, I noticed code enforcement today, they were doing a great job. They were taking weekend signs off telephone poles. Garage sales, cars for sale, code enforcement. That's what we're coming down to. Granted, perhaps you guys could put a word in somewhere along the line. Perhaps Willa can look into it. That's something to put some teeth into, versus half a dozen buildings that are being built without permits in Costa Mesa and need to be turned in by citizens. But guys, as I mentioned at the last council meeting, it's really not hard to do the right thing and stop passing the buck. Just do the right thing. I said it at the last council meeting, you know, Christ did not lead, he led by example. He wasn't the exception. It seems like these days everything is the exception. Let's fix that. Thank you.
Anyone else? Okay, I will close public comment. And that will then take us to commissioner comments. Commissioner Russell, do you have any comments tonight? No. Commissioner Navarro-Woods.
Yeah, so tomorrow there will be a study session / open house to come and learn the facts about small cell facilities. It'll be held here in council chambers from 5 to 7:30. And I hope to see a lot of you there. I know a lot of our residents have had concerns and questions about small cell facilities, and this would be a great time to come and address those concerns.
Okay, thank you very much. Commissioner Zick.
Nothing tonight, thank
Okay,
you.
Vice Chair Harlan? Nothing tonight. And I have nothing. That will take us then to the consent calendar, which we have nothing under there tonight. So we'll go to public hearings, and that will be public hearing item number 1, Julie.
Public hearing item number 1, conditional use permit PA-16-63 to operate a residential facility serving mentally disabled persons in a 6-unit housing, in 6 units housing up to 30 residents, and appeal of denial of reasonable accommodation RA-19-06 for relief from certain requirements of the zoning code, operated by Insight Psychology and Addiction at 2641 Santa Ana Avenue, Units A through F. This is a call to report any ex parte communications.
Commissioners, any communications to report? Okay, seeing none, thank you, Julie. Ms. Bowens-Clean, it's yours.
Mr. Chair and Commission, I'm Willa Bowens-Clean. I'm the zoning administrator. So before we start this hearing tonight, which is an appeal of reasonable accommodation request and conditional use permit at 2641 Santa Ana, units A through F, The city of Costa Mesa experienced a significant increase in group homes several years ago. These homes generated a number of complaints regarding secondhand smoke, overcrowding, parking, noise, and impacts to the character of neighborhoods. Under state and federal law, persons with mental disabilities are considered disabled. The Federal Fair Housing Act amendments and the California Fair Housing Act prohibit the enforcement of zoning ordinances that would discriminate against equal housing opportunities for persons with disabilities. This means that the city is very limited in its abilities to take actions that would treat residents who are disabled differently from residents who are not disabled. State housing law sets forth occupancy standards for residential units. These standards are very minimal, meaning the typical single-family detached home in Costa Mesa could accommodate more than 20 people under state law. The city is not allowed to impose occupancy restrictions that are more stringent than those found in state law. However, the city's housing element does include standards for overcrowding, and we are reviewing group home applications for consistency with that standard. The Lanterman Act requires cities to treat state-licensed residential care facilities serving up to 6 residents as a residential use. These facilities are exempt from any city regulations that do not apply to all other residential uses in the same zone. The city carefully crafted regulations that respect federal and state laws protecting the rights of the disabled while also protecting the quality of life in the city's residential neighborhoods. The city recognizes that group homes do provide a benefit to the community in that they offer disabled individuals the opportunity to live in a comfortable residential environment. However, these facilities are often dissimilar to other households and neighborhoods in that they house all adults. The residents tend to live in the home for a relatively short period of time and often don't establish ties in the community. The facilities do not operate as single housekeeping units, that the residents generally have no say about who lives in the facility, and the number of occupants, while consistent with state housing law, is often higher than the typical household size in Costa Mesa, creating additional demands on city infrastructure and parking. For these reasons, the city decided to impose a separation requirement between facilities to avoid an overconcentration of group homes in any neighborhood. Not only does this standard preserve the character of the city's neighborhood, it ensures that the needs of the disabled are addressed by allowing them to live in homes in traditional neighborhoods, as opposed to a more institutional setting that might result if group homes were clustered in the same area. The city requires any group home to be at least 650 feet from any property that contains a group home, state-licensed residential care facility, or state-licensed drug and alcohol treatment facility. Group homes and licensed residential treatment facilities are limited to 6 residents plus a house manager in single-family zones. Facilities licensed by the state to serve 6 or fewer residents are exempt from city regulation other than those regulations that apply generally to all other dwellings. Facilities that are not licensed and have 6 residents or fewer must obtain a special use permit from the city. In multifamily zones, facilities with 7 or more occupants require approval of a conditional use permit by the city, whether or not they have been licensed by the state. Operators of facilities that are not licensed by the state are required to obtain an operator's permit from the city. As part of this permit, the city requires the operator and staff to undergo a live scan background check. In addition, a house manager or staff member must be present at all times, and any resident who is evicted or whose residency is involuntarily terminated must be offered transportation to the resident's permanent address. A group home is not allowed to provide treatment services, counseling, or other services without a license from the State Department of Health Care Services. The application before you tonight involves a group home with 7 or more occupants that is not state licensed. The item before you is Conditional Use Permit PA 1663 and Reasonable Accommodation RA 1906, a request to operate a group home housing up to 30 adults plus 2 house managers that are on site at any one time in a 6-unit complex. The applicant also submitted a request for reasonable accommodation to allow this facility to be within 650 feet of 2 other properties that contain a total of 4 state-licensed drug and alcohol treatment facilities, or to exempt this use from the city's group home ordinance, thereby allowing the use to be permitted by right. The request for reasonable accommodation was denied, and the applicant appealed that decision to the Planning Commission. The site currently operates as a group home. Code enforcement first opened a case for a sober living home at this property in June 2015. The site houses up to 30 residents, plus 2 house managers that are on site at any one time. There are 6 2- to 3-bedroom apartment units on the property. There have been 12 complaints to code enforcement expressing concern with the number of people and type of activity occurring within the 6 group homes. The complainant also expressed concerns with smoking, noise, general complaints about the group home and its lack of permits, bottle rockets, and large items at the curb. According to the police department, between January 2015 and the preparation of this report, there have been 17 calls for service, including calls for disturbances and noise, suspicious mail, medical aid, annoying calls made to a resident as a victim, and missing adult, all attributable to the property. Staff has received 2 emails in response to the notice for this Planning Commission meeting in protest to the project. The applicant originally filed a conditional use permit for a sober living facility under Insight Psychology and Addiction on October 26, 2016. In response to the city's notification that 4 state licensed facilities existed within the 650-foot radius of the property, a request for reasonable accommodation was filed on August 3, 2018. However, the use is now described as housing for mentally disabled. The applicant filed a revised conditional use permit to reflect the change into housing for mentally disabled on February 4, 2019. However, the revised information provided by the applicant was still filed on Insight Psychology and Addiction letterhead, consistent with the original conditional use permit filing. The Development Services Director denied the reasonable accommodation request on April 5, 2019, and the applicant appealed the decision on April 12, 2019. The subject property is located on Santa Ana Avenue between Del Mar Avenue and Mesa Drive. The property is located within 650 feet of 2 properties containing a total of 4 state-licensed drug and alcohol treatment facilities, 2 at 319 University and 2 at 326, 328 University Drive. Both units at 326, 328 University Drive are on a single parcel. All 4 units contain 6 residents each. Although located in the County of Orange, both properties fall within the City of Costa Mesa's sphere of influence. The development consists of a single-family dwelling constructed prior to the city's incorporation, 2 single-family dwellings constructed in 1960, and a triplex constructed in 1979 for a total of 6 units. All the parking is accessed from Santa Ana Avenue via a driveway along the south property line. The project is a rental as it has not been divided into any kind of a residential common interest development. All units are currently operated as a single facility. The subject property is non-conforming in terms of density, lot width, open space, rear setback, parking, driveway width, and driveway landscaping requirements. The development predates many of the city's current requirements. Additionally, it appears that the required open space has been removed to reconfigure parking, and the single-car garage of Unit C has been converted to an office. Both have occurred without city permits. The separation map depicts state-licensed treatment facilities, 6 or fewer, as these facilities are permitted by right per state law. No permit from the city is required. Group homes, residential care facilities, and state-licensed treatment facilities for which the city has issued a CUP to serve more than 6 adults. Group homes serving up to 6 adults for which the city has issued a special use permit. Group homes, residential care facilities, and state-licensed treatment facilities which require but have not obtained a CUP or SUP and are operating in violation of city zoning regulations, and state-licensed facilities operating outside of the city's limits but within the 650-foot radius of the proposed facility. There are 4 state-licensed facilities located within the 650-foot radius of the subject property and in unincorporated county area at 319A University Drive, 319B University Drive, 326 University Drive, and 328 University Drive. All 4 units are state-licensed drug and alcohol treatment facilities that serve up to 6 people, some for men only, some for women only, and some co-ed. The applicant has requested a reasonable accommodation to allow this facility to be located within 650 feet of 2 parcels, each containing 2 state-licensed facilities, or to exempt the use from the city's group home ordinance, thereby allowing the use to be permitted by right. The director denied the reasonable accommodation request based on his determination that not all of the required findings to approve the request for reasonable accommodation could be made. The request for accommodation was denied for the following reasons. First, the director found that approval of this request is not necessary to allow the disabled to use a dwelling in Costa Mesa, although it is necessary to allow the disabled to live in these particular units. There was no justification provided to support the request to allow the facility based on provision of serving individuals with mental health and cognitive disabilities. The code considers this a group home use, and therefore there is a separation conflict with the 4 state-licensed facilities existing on University Drive. The residents do not live as a single housekeeping unit as defined by Costa Mesa Municipal Code, in that they have no control over who else resides at the facility. Rent is collected from each resident, expenses are not shared, and residency tends to be transient. Approval of the request to consider the residents of this facility to be a single housekeeping unit or to otherwise exempt this facility from regulation would be contrary to the purposes and intent of Ordinance 1511. Allowing a group home to be considered exempt from the requirements of the municipal code is not necessary to allow disabled persons to reside in residential neighborhoods. Number 2, the applicant did not demonstrate that the accommodation is consistent with surrounding uses in scale and intensity. The subject facility does not operate as a single housekeeping unit or even 6 single housekeeping units, making it dissimilar to the composition of households on surrounding properties. The facility is occupied solely by adults at a higher occupancy than is typical in Costa Mesa. Each resident is allowed to keep a car on the property, providing opportunities for parking conflicts with owners of nearby properties who also rely on on-street parking. The city's intent in adopting its group home regulations was to ensure an overconcentration of group homes did not occur in any neighborhood. This facility would contribute to overconcentration given that it includes 6 units on the single parcel. Number 3, the applicant did not demonstrate that accommodation is necessary to allow persons with disabilities an equal opportunity to live in a residential setting. The city received applications for 57 sober living homes, which does not include applications that were withdrawn prior to some action taken by the city, and 11 licensed treatment facilities that are subject to compliance with ordinance numbers 1413 and 1511. 12 sober living homes serving 6 or fewer residents have been approved by the city, and 2 sober living homes serving 7 or more residents have been approved as well. In addition, there are 5 social rehabilitation facilities, 6 adult residential care, and 58 existing state-licensed drug and alcohol facilities in Costa Mesa that are exempt from city regulation or have already obtained the required conditional use permit prior to the adoption of Ordinance 1511. No evidence has been submitted to indicate that the number of group homes existing or potentially allowed in compliance with the city's standards is inadequate. This 58 unit number does not include 8 outside of the city limits that have a Costa Mesa mailing address, nor the solid landings facilities that reach the amortization date pursuant to the settlement agreement that were removed. No evidence has been submitted to indicate that the number of group homes and drug and alcohol residential care facilities existing or potentially allowed in compliance with the city's standards is inadequate. Finally, the director was unable to find that approval of this accommodation would not alter the city's zoning program. The city's regulations seek to ensure that disabled persons recovering from addiction can reside in a comfortable residential and environmental setting versus an institutional setting. The city determined that housing inordinately large numbers of unrelated adults in a single dwelling or congregating group homes in close proximity to each other does not provide the disabled with an opportunity to live in normal residential surroundings, but rather places them into a living environment bearing more in common with the type of institutional campus dormitory living that the state and federal laws were designed to provide relief from for disabled persons. The city has determined that a separation of 650 feet is appropriate between group homes and licensed treatment facilities. The subject property is 476 feet to 636 feet away from those 4 state licensed facilities on 2 properties in the 300 block of University Drive. If the denial of the reasonable accommodation is upheld, the facilities will not be in compliance with the city's separation standards unless the Planning Commission makes a finding that approval of this conditional use permit will not result in an overconcentration of such units in this neighborhood. The Commission must make findings to approve a conditional use permit. While some of the findings can be made, key findings cannot. As required by the group home ordinance, findings for the granting of a conditional use permit as found under Costa Mesa Municipal Code Section 13-29G2 must be met in order to approve the project. The Commission must find that the group home would be compatible with the residential character of the surrounding neighborhood, that the use will not be materially detrimental to the health, safety, and general welfare of the public or otherwise injurious to property or improvements within the immediate neighborhood, and that granting the conditional use permit will not allow a use, density, or intensity which is not in accordance with the general plan designation of the property. The municipal code specifically requires a separation of 650 feet between group homes to avoid an overconcentration of such facilities in any neighborhood. The clustering of such facilities could lead to an institutional feel in the neighborhood. The city's regulations are consistent with the goals of state and local laws that seek to provide disabled persons the opportunity to live in residential settings. There are 4 state licensed facilities on 2 parcels serving a total of 24 residents within 650 feet of the subject property. Therefore, approval of this conditional use permit would contribute to overconcentration of group homes in this neighborhood. In addition, 5 of the 6 units are considered overcrowded. 4 to 6 residents reside in each unit, resulting in an average of 1 to 1.5 persons per room. However, the city's general plan defines overcrowding as a housing unit occupied by more than 1 person per room. Additionally, all 30 residents and the on-site managers are adults. The average household in Costa Mesa has 2.2 individuals over the age of 18. Lastly, 12 parking spaces exist on the property. 9 garage spaces and 3 open parking spaces are provided for the 6 units. However, up to 30 adult residents occupy the 6 units, with 2 managers on site at any one time, potentially resulting in impacts to parking in the neighborhood. The City Council has determined that an overconcentration of group homes would be detrimental to the residential character of the city's neighborhoods. The use of a parcel to house up to 30 adults with 2 on-site managers in overcrowded conditions is contrary to the general plan's goal to maintain the character of residential neighborhoods. And lastly, the application was originally submitted as a sober living facility. The applicant has since changed the description, stating that they are now providing housing for the mentally disabled. However, staff notes the following. The revised information was still submitted on the same letterhead for insight, psychology, and addiction. The email address is still insightrecovery.com. Although the applicant stated in the city's group home plan home checklist that they submitted that they do not need an alcohol and drug use policy required for the operator's permit, their residential rules contain a drugs, alcohol, and prescription medications policy. The resident rules also require drug and alcohol screenings. The applicant states that had we processed their CUP when it was originally submitted, that there would not have been a separation conflict with the properties on University. However, the original conditional use permit application was filed on October 26, 2016. the state issued licenses for the two facilities at 326, 328 University on May 5th, 2016. Therefore, there was a separation conflict existing at the time that the application was filed. In the reasonable accommodation application, the applicant states that between 2015 and 2016, Ensite utilized the property as a sober living home. During this time, all residents were required to have a primary substance abuse diagnosis. Without this facility limiting the residents to mentally disabled and specifically not in recovery from drug and alcohol abuse, it cannot be determined that the facility will not operate by default a sober living home. Regardless, the separation conflict applies, therefore the facility does not meet code requirements. Based on denial of a reasonable accommodation, the facility does not comply with the city's adopted standards for separation between group homes. Approval would result in an overconcentration of group homes in this neighborhood. Therefore, the finding required by the municipal code to approve this conditional use permit cannot be made. Consequently, staff recommends that the Planning Commission adopt a resolution to uphold the director's denial of the request for reasonable accommodation RA 1906 and deny conditional use permit PA 1663. Staff notes for the record that the resolution was reviewed and approved as to form by the City Attorney's Office. Staff is available to respond to any questions the Commission may have. Thank you.
Thank you, Ms. Bowens-Colleen. Commissioners, are there any questions immediately of staff before I open the public hearing? Okay, seeing none. Commissioner Zick.
My first question has to do with the timing of the state licensed facilities, the May 2016. So my question is this: had those facilities not been licensed and didn't exist at the time this application was submitted, October 26, 2016, and if there were no other concerns or issues with regard to this applicant's application and operation, if there were no other issues, then relative to the separation requirement, there would have been no conflict, correct?
That's correct.
Okay. Now, if the CUP had been approved based on that, and again, assuming there were no other issues with the application, and then these two facilities that the state ultimately licensed popped up, would the city have had any say at all about them being put into operation and being licensed by the state?
No.
And so if the timing of things had occurred in that sequence, then, and again, assuming there were no other issues with the application, then we'd be sitting in a condition where the state facilities would be licensed and operating, and this facility would be operating under a CUP, correct?
That's correct.
Okay. The 650-foot separation requirement, I know there's some question about that, and I think you answered it already, relative to facilities that exist outside the city, in particular these state licensed facilities that are in the county. And you mentioned they were in the sphere of influence.
That's correct.
Okay. I want to ask you to explain beyond that, because I sort of understand that. If we were on the border, if the facility was on the border of Huntington Beach, and there were facilities in Huntington Beach within the 650-foot radius, would we have the similar view?
Yes. We
And
would.
Newport Beach, same thing?
Correct.
Okay. When a CUP is issued and approved, that runs with the land, correct?
That's correct.
And so if a CUP was issued to this applicant, and then they later decide not to operate, maybe even sell the land to somebody else, and maybe the property is simply occupied by people not with any special condition or situation, and maybe later the land sells a third time to somebody that decides they want to set up a group home. Does the CUP still exist and allow them to do that?
If it's been greater than 180 days and it's not been used as a group home, it's been rented as regular units, no, it would not apply anymore.
Got it. Okay. Thank you for that. There's a comment in the staff report that indicates that the applicant presented no evidence that it operates as a single housekeeping unit. They're not claiming or trying to represent that they're operating as a single housekeeping unit, correct?
That's correct.
Okay, so the fact that they presented no evidence isn't necessarily a conflict. You're simply indicating they're not claiming to be a single housekeeping unit, and we don't accept that they are a single housekeeping unit. Okay. And then when you talk about the density, and you mentioned that the average occupancy in Costa Mesa of adults over the age of 18 is 2.2. There's also mentioned in the staff report that the average in the city's general plan is 2.68. Could you explain that?
That's for the total family size, but for average per unit is 2.2 adults over the age of 18.
Okay. And this project would be 5 adults per unit as an average. So
Yes.
over double the average in the city.
Yes, correct.
When you talked about the condition of the property, you used the term non-conforming. And when you use that term, I think of the term existing non-conforming or grandfathered, meaning it's an acceptable condition that predates changes in the code. So it's an acceptable constructed condition. It just predates the current codes. Is that the way you were trying to characterize it?
The property, with the exception of the one garage unit, and it appears the open space is legal nonconforming, but it does appear, we have a building permit for Unit C that shows that it was a detached residence with a single-car garage, that appears that it's been converted to another use. Additionally, there does not appear to be 40% open space at this time. The parking design differs from the approvals back in the 70s, and as well, there was a land use restriction recorded against the property requiring that they maintain 40% open space on the site.
So we'd almost go so far as to say that they're out of compliance. It's not an existing non-conforming, it's worse than that.
There's several items that are just plainly legal nonconforming. I believe that if they converted the garage back to a garage use and reconfigured the landscaping as originally approved, then it would just merely be legal nonconforming.
So when we get an application for a use, any use, but obviously we're talking about this one, and the condition of the property is such that there's been non-permitted construction, I guess my question is, would there be any reason we'd even continue to process an application for a use in a property that has unpermitted construction? Wouldn't we expect that to be remedied before we'd even consider an application for use?
We decide that on a case-by-case basis. Sometimes it makes more sense to go ahead and process the application and take care of those concerns as part of the application. Sometimes it makes more sense to correct those items before going into public hearing.
Okay. And under this particular finding, one of the 8 findings that would have to be met, all these questions so far are under the one where we speak to intensity, is the issue of the code enforcement investigations and the other calls for service, are those the sorts of things that would have a bearing on the question of intensity? Or if not, then what how would you describe her interest in intensity?
If I understand your question correctly, you're asking specifically about the calls for service information. Staff typically provides calls for service information as a standard part of our staff report. It's mentioned in the resolution. It has no bearing specifically as to the findings, other than to show compatibility with the neighborhood, which goes to the CUP findings.
Okay. Then there's another finding that must be met that speaks to the idea of the existing supply of facilities. And I understand what you've presented in terms of the number of group homes and applications which have been approved and et cetera, which is quite extensive. And I'm also familiar with the documentation we've received from the applicant, which explains a position that their use is significantly different from these uses and makes a case that there is not an adequate supply of facilities for the use that they have. But here's my question. All 8 of these findings must be met in order to approve a reasonable accommodation. And in terms of the scale and intensity, in terms of the finding that the requested accommodation is not necessary to enjoy a dwelling as opposed to these specific dwellings. If every other finding, let me say it a different way. If it was an absolute fact proven that there was an inadequate supply of facilities in the city for this specific use, but the other findings were not satisfied, that would not be a sufficient argument for approving the reasonable accommodation, correct? All 8 must be found.
That's correct. All of the findings would need to be able to be made.
Okay. And then my last couple of questions deal with the last finding, which talks about whether the accommodation would result in fundamentally altering the city zoning. And the basis of that, or the idea behind that, is that these group homes want to be in a residential neighborhood as opposed to institutional environment. And an overconcentration creates a condition under which the neighborhoods are less residential and are more institutional, which is counter to the objective and counter to the city zoning. So here's my question. Is there institutional zoning within the city in which a group home could elect to operate if they chose to, as opposed to in a residential neighborhood?
I believe so. Let us take a quick look and confirm, and we'll get back to you definitively.
Okay.
Thank you.
Thank you, Mr. Chairman.
Thank you. Commissioners, any other questions? Okay. I will open the public hearing with a statement into the record. People residing in group homes may be considered disabled under law. They are protected under the law, and they should be treated with the same respect we all want to be treated with. Such persons have a right to live in residential neighborhoods, and the city of Costa Mesa is serious about protecting that right. The city also knows that poorly run group homes can be damaging to the community and dangerous to their residents. If an operation is having a negative impact on your community because of nuisance behaviors, or if you believe it is endangering its residents, please tell us about specific problems. But we will not entertain comments that people in recovery or living in group homes do not belong in our community. We do not condone and will not take part in discrimination. Having said that, I'll ask the applicant to come forward, please. Good evening, ma'am. You have the floor, and you can take as much time as you need.
Thank you. Good evening, commissioners. My name is Mary Helen Beata Ficato, and I'm here representing not only the property owner, but Insight, who is the operator of the transitional housing that's occurring on this property. I'm here tonight appealing the director's decision to deny applicants' request for reasonable accommodation, and then as it would follow, the application for the conditional use permit. Before I get into the merits of this appeal, I want to describe for you a little bit about what Insight does, because I think in the opening remarks, there was some allude to the fact that the use changed kind of as a self-serving purpose. What you'll see in the documentation that was submitted is the change from sober living to mental health or transitional living for the mentally disabled occurred at the end of 2016. The reason that this became an issue is because it took more than 2 years from when Insight filed its application for a conditional use permit before the city began corresponding with it, or 21 months to be exact, before they started corresponding. So the issue of what type of use was occurring at the property then didn't come up before then. So it's not that once applicant knew where the staff was leaning toward that it then decided that it was going to operate in a different way. This was actually more of a clinical and administrative issue that came up just with how the industry was changing at the end of 2016, that Insight's board decided to move in the direction of mental health. I will tell you that today, Insight is one of the only treatment providers here in Orange County with facilities even outside of Costa Mesa, offering different levels of care for mentally disabled individuals. Much of the agenda report, as well as the director's denial, was directed towards sober living. And hearing tonight, I think it makes a little bit more sense for me because the city is contending, I think, well, not expressly, that this change in use only happened for purposes of filing this CUP and request for reasonable accommodation. The problem that I have with that is there are distinct differences between how applicant operates this facility, distinct differences between the clinical diagnoses of the individuals who come to live in this facility. And so everything that's been submitted with regards to the availability of housing for the mentally disabled has focused on what's available for individuals recovering from drug and alcohol addiction. I imagine that in the packets that were given to all of you, you got my original request for reasonable accommodation. I detailed over numerous pages not only the differences in applicants' transitional living, but why sober living homes, just by virtue of how they operate, cannot serve the needs of the mentally disabled, not just the residents who come to live at this facility, but people with mental health issues in general. Before I get into exactly how this facility is run, I wanted to bring up the issue of these complaints, and only so that the commission has a chance to address it before we go further along into the merits of the appeal. In the director's denial that happened in April of 2019, it never once mentioned that there were any complaints after 2016, even before then, with regards to the use of this property. In fact, if you look at the original denial, there was a finding with regards to the health and safety, and there is a statement by the city that says that they could find that no evidence that granting this request for reasonable accommodation would be or would pose a threat to the health and safety of the people of Costa Mesa. So I was very surprised when I didn't see it in the original denial. It wasn't a subject of the appeal that I filed, and only in Friday's agenda report for this hearing did it first come up. I know we have at least one attorney on this commission, but I will tell you that there's a fundamental problem with, for the first time, this issue being brought up tonight, and myself not having an ample opportunity to look into those. More importantly, why I'm bothered by this is that I know that with regards to at least one incident, which is this bottle rocket launching, code enforcement came out to the property. I was called as in-house counsel. I went out to the property, and I was able to show code enforcement from our own shift reports that our residents had complained about bottle rocket launching from 2 properties over to the right, if you were looking at our facility. And I showed that report, and code enforcement assured me that that was fine, that they would go and check it out. So to see that one of these allegedly 12 complaints, which, by the way, in the staff agenda report from Friday, says that all of these incidents happened up to 2006. And then tonight, for the first time, I am now hearing that there were complaints going through 2019. So I have a very big concern with complaints popping up between when I filed my appeal and last Friday, and then additional complaints popping up between Friday and today. And so I would ask the commission that if it was inclined to look at these incidents and base recommending to uphold the denial of this request, that this hearing tonight be continued to allow me, on behalf of the applicant, to look into these complaints and have an opportunity to respond to those. And I thought I'd bring that up first, just in case that was going to be an issue. Perhaps you wanted to continue this and I don't go into the rest of my argument.
I would just probably suggest that you continue on with it, and we'll see what the commission wants to do following your testimony and receipt of testimony from the public.
Okay. So back to how this facility operates. Insight has social rehabilitation facility outside the city that it provides psychiatric care. It's actually an inpatient as that word is used. It's not a hospital setting, but it's for individuals who are either coming off of a 5150 hold or don't necessarily meet the criteria for a 5150, but really need around-the-clock, 24-hour supervision for their psychiatric illnesses. That facility we operate, and it's outside of Costa Mesa. The transitional living facility that is in Costa Mesa is for the next transition that individuals make outside of a 24-hour setting. So when the city says, well, we have 5 social rehabilitation facilities and 6 adult residential care facilities, and again, I'm not sure why the substance abuse is coming up, but the 58 licensed drug and alcohol facilities, all of those settings, with the exception of the 14 sober living homes that are mentioned, are all 24-hour residential care facilities. Medications, there's assistance with medications. There's also meals that are required to be provided by the state of California. Not that they're provided by the state, but the state requires it. They basically, they're under supervision all the time. They don't leave the facility without staff. And so this facility that's the subject of the appeal tonight does not operate in that manner. So then what we have left is 14 sober living homes, which, as detailed in my request, do not meet the needs of people with mental health issues. 99% of the individuals who come to Insight and reside in its transitional living homes do not have a substance abuse issue. They actually have a serious, non-chronic mental health issue. I know Willa had mentioned something about how do we know that it won't be a sober living. I am willing to represent to you on behalf of the applicant that as a condition for approval, which conditions happen quite often, that applicant will agree that that would be an admission criteria. They're already using the property as such. So to have this commission say that they would recommend approval with that condition would be perfectly fine with the applicant. I know one of the other issues that comes up with sober living homes is patient brokering and also curbing. I'm sure if you're not familiar, you'll let me know, but those issues typically come up. We don't have those kind of issues at Insight, and it's partly because, as well as the smoking, Typically, recovering addicts, and they go into sober living homes, they've picked up a smoking habit if they hadn't had one already. They're giving up one thing only to pick up another thing. So we don't have those kind of smoking issues. Willa also brought up the point of drug and alcohol testing. So one of the fundamental differences between people in recovery from drugs and alcohol and people with mental illness is that people with mental health issues oftentimes have trouble taking their medications. They either don't want to be on medications at all, very in stark contrast to people in recovery, or they start to take them and then they feel better and they think they don't need to take them anymore. And so, yes, Insight does perform toxicology screens on its patients. They're not the kind of toxicology screens that happened in sober living homes or treatment facilities for people with substance abuse because they're not occurring all the time. The Insight is checking levels. They're looking for the presence of their psychotropic medications. They're looking for, levels as well as presence to know are they taking them the way that they're supposed to be taking them. So again, yes, those kind of things are occurring. They don't occur with the frequency that happens with drug and alcohol treatment, and they're for entirely different purposes. This city, as well as cities throughout the state, are dealing with a homeless issue. And I know this city council in particular is very focused on dealing with that homeless situation. And it's a key priority for the current city council. Applicants' facilities, like I said, don't have the similar concerns and issues that sober living facilities do. And in fact, what applicants trying to do is help individuals address those mental health issues so that they don't end up homeless. Somebody typically doesn't wake up one day and decide that they're going to be homeless. They suffer from a mental health issue, they lose their job, they lose their families, and then pretty soon they're on the streets, and the nature of their illness, actually they begin to like where they're living. And that's why you'll find a lot of people that are living on the streets homeless actually prefer to live that way. What applicant is doing is trying to stop that problem before it even starts. So applicant doesn't want to cause additional concerns or issues here in the city of Costa Mesa. It actually wants to join with the city of Costa Mesa in order to alleviate those problems before they happen. The staff report identifies 5 reasons to uphold, and I keep saying staff report, the agenda report, 5 reasons to uphold the director's denial. And those 5 things are listed up on the screen. I'm going to actually make it pretty easy for this commission because we can get rid of those pretty easily. First, the staff report recommends, or actually says that because applicant has 30 beds, that this is contrary to what federal HUD standards are that say 1.01 people per room is overcrowding. So in order to alleviate concerns with overcrowding, applicant is voluntarily agreeing to reduce the number of beds at this property to 25, which would bring that down to 1 person per room, which is below what the federal HUD standards are. The second thing that we can eliminate is the parking issue. Yes, it's true that Insight does allow transitional living clients to bring their vehicles. Most of them don't. And so Insight is willing to agree, voluntarily again, that it will reduce the number of residents and staff allowed to bring vehicles to the property to 10 for residents and 2 for staff. And those 12 total parking spaces are all available on site, and that would include the 2 staff company vehicles that are used to help with transporting patients, these individuals who need them, whether it's to the grocery store or to appointments that they have, job interviews, that sort of thing. So that would eliminate number 3. Actually, Willa, if you push that. Yeah, so that eliminates number 2, and then if you do it again, it also eliminates number 3. Number 4 I've already talked about, and again, I just like the opportunity to be able to look into those. I know that the bottle rocket launching didn't apply to the applicant. And so it really makes me question what exactly these complaints are that are being talked about. I've also talked about the evidence of inadequate housing supply. I think that's probably one of the easiest things, aside from the two that we're just conceding on, to see, because really once you eliminate these 24-hour care facilities, you only are left with 12 sober living properties, which again, don't even come close to meeting the needs of the mentally disabled. So then what we have left is the 650-foot requirement, and this is really, I think, what tonight is all about. First of all, we look at the purpose behind not only zoning laws in general for the city of Costa Mesa, but also for the group home ordinance. The purpose is pretty clear, and I hopefully everybody got a copy of what I submitted before noon today. But I talk about how the purpose is to preserve the residential character of Costa Mesa neighborhoods. It's right there in the code. And so what the city is doing, and by the way, 21 months after we filed for our conditional use permit is when they notified us of the conflict. 21 months later, it's, hey, there's 2 county properties, and those 2 county properties are within a 500-foot radius of applicant's property. There's a lot of concerns with this. The first one is you have 2 properties that are outside the city of Costa Mesa, and as Commissioner Zick pointed out, had all of the other issues that are mentioned in the agenda report, if those weren't in contention, even if applicant, and I think this is so important, if applicant had filed on day 1 when ordinance, I think it was 15, right, 11-15, the group home ordinance, if it had filed the day after the group home ordinance was passed, those 2 facilities would still exist in the county. And had our CUP been acted on earlier. And what I'm saying is this, the group home ordinance has no effect whatsoever on those 2 properties in the county, none at all. They're allowed to be there, to be established, to be licensed by the state, to continue to operate with, regardless of the group home ordinance. The city of Costa Mesa doesn't get to decide whether those exist or not. Now, there was this mention of sphere of influence, and I hadn't heard this before tonight with regards to this appeal, but if my recollection serves me, I know that there's a state regulation with regards to sphere of influence, and it comes up in cannabis when dispensaries want to go in. And that state statute actually mentions the word radius for how you calculate that distancing requirement, which brings me into my next point. What I found very interesting was that in all of the mailing notices that went out, the statute says, or the ordinance says, that you have to provide notice within a 500-foot radius of the subject property. However, even though one of those facilities in the county, on county property, is 546 feet away from applicants, it wasn't provided notice. And I'm not saying that there's a notice issue, because there isn't. They're outside of the city's jurisdiction, and so it makes sense that they weren't provided notice. But I also think that it's a contradictory argument to say, hey, those properties are relevant for determining whether the 650-foot requirement is met, but at the same time, they're not relevant to whether we grant the request for reasonable accommodation to applicant. Even more importantly is when you look at the municipal code that talks about the mailing notice, they don't just say 500 feet of the property. They say 500-foot radius. So it was very clear in that code section that in order to calculate the 500 feet to give notice, that you use a radius, a 500-foot radius. In stark contrast to the group home ordinance that says 650 feet between the two properties measured point to point. That's it. There's no reference at all to the word radius, which is obvious that if it was intended to be applied as a 500-foot radius, that word would have been present in the code, and it isn't. And I can tell you, as an attorney who's been practicing for almost 18 years, that basic rules of statutory construction say that courts, when they're reviewing this, are going to look at what the plain meaning of that word is and that phrase that's in the code. And since the word radius is not there, and even more telling that there's another code section that uses the word radius, it's that the inference is that it was never intended to be applied in that manner. Now, the city of Costa Mesa will have a slight little problem with that, because if this request, and this is by no means a threat at all, I just think that the commission should be apprised of all of the facts so that they can make a decision based on everything, is that if this reasonable request is not granted, this will be challenged. And this is an issue that can have far-reaching implications, not just for applicant, but also for all of the other permits that have come before the city. Because if a court were to determine that what I'm arguing here today is that that word radius was not intended, that the measurement was not supposed to be in a 500-foot radius, and they say, in fact, it's just 500 feet, not the way crows fly over walls and rooftops, but instead the way people walk and drive and bike, then that means that all of the permits that have come before, even the ones that were denied, more importantly, that if that same radius calculation was used, the city of Costa Mesa is going to have a can of worms that gets opened up. But you see, tonight when you're ruling on this appeal that I filed, you don't even have to go there. You don't have to grant or recommend granting this request based on the fact that a radius was applied when it shouldn't have been. You can make this for a number of reasons. One, the fact that it's two county properties. There is no other property in the city of Costa Mesa that is within 650 feet of applicant's property. So you can base it on that. You can also base it on, and I think it was Commissioner Zick who brought it up, was, actually, no, I'm sorry. I stand corrected. He did not. It was up on the screen. It said, I believe Willa said, you can either, if you can still grant the request for reasonable accommodation if you find that there's no overconcentration. And I submit to you that with what I've said here tonight, that applicant is voluntarily reducing the number of beds to 25, which there was a footnote because the plans show 25 rooms, but staff didn't count the 3 bedrooms in Unit C as opposed to the 2. There's actually 3 bedrooms, and they're on the project plans. Interesting. I did forget one thing, so I'll digress for 1 second. It has been repeatedly mentioned that applicant has been using the garage of Unit C as an office without a permit. Code enforcement came out. What applicant was cited for back in 2016, and I actually have copies of that citation, was that the garage had been carpeted. There was a pool table and a couch in there, and so it prevented vehicles from being parked inside the garage. Immediately after we were cited, the carpet was removed, and the pool table and couch was moved or were moved in order that vehicles could be parked in the garage. Since that has happened, that garage, you can park vehicles in it. In fact, we used that opportunity to make sure that the other 5 garages could also have vehicles pulled in them. So I'm actually baffled as to why there's this continual mention of Unit C being used as the garage being used as an office. Contrary to what the city mentions in the report is if you look at the project plans, Unit C shows that 3rd bedroom, I believe it's labeled site office, that's where staff has a computer and they're able to see the 24 cameras that have been installed around the property. I've addressed the complaints. I've asked for continuance if the commission wants to base upholding the denial on that. Talked about the 650-foot requirement and the fact that You can find there's no overconcentration with what applicants agreed to, which means you don't even have to address the 650-foot requirement or the fact that applicant doesn't meet it. You can also look to the fact that there's 2 county properties. Those are the ones that are in conflict, and make a recommendation to reverse the director's denial based on the fact that they are county properties. And then once we agree to the on-site parking and the reduction in beds, the overcrowding issue is also gone. There was some mention about landscaping, and to be honest with you, again, it's never been raised before, but I can tell you this, hopefully right, that if landscaping is the issue, I believe what Willa said was if the garage of Unit C is not being used as an office, or I think she said if it was put back, which it just isn't an office, that the only issue would be landscaping. I can tell you that applicant would be willing to make whatever corrections it needs to do to the landscaping in order to bring that into conform, to make it conform. And I believe what Willa said is then it would be legal non-conforming. There's obviously a mental health crisis in this country, and the homeless problem is also a result of that mental health crisis. Applicant is really bending over backwards to make sure that a very needed service is available to people who need it so that we can do our part to fix that. And so we're bending over backwards to agree to things that we don't have to, but in order to alleviate concerns that the city will have. And so I appeal to you tonight to do what this commission needs to do. And you don't even need to bend over backwards. It's there. Everything that you need to reverse or to recommend reversing the director's denial is in front of you. You just need to now do it. Do you guys have any questions for me? Something to let me know you're at least paying attention? No? Okay.
Okay, go ahead, Commissioner Woods.
All right, I guess I'll go. So you were referring to the section code and the zoning code, and so we looked it up as you were talking. And if you look under, I was particularly interested in your assertion that that there was a distinction between 500-foot radius and 650 feet separation, but in the zoning code, it doesn't make any distinction on how far away. It does say you have to be should be a separation of 650 feet, but it doesn't expressly say that it needs to be within the city of Costa Mesa. And I think maybe you may have misinterpreted that, and you're asserting that the zoning code specifically states that separation has to be within city limits, but that's not what the zoning code says.
No, you're correct. That may be what I was getting at, because I don't think I said that. What I said was that the code actually states in its purpose that the purpose of the group home ordinance code sections are to preserve the residential character of the Costa Mesa neighborhoods. So there, it was very specific to Costa Mesa. The other thing was that it doesn't mention the word radius. That was the other argument. But the code provision that talks about mailing notice of some sort of, zoning application, it specifically says 500 feet radius. And so it was the absence of the word radius.
Okay.
But I do absolutely agree with you that it doesn't say only in Costa Mesa, but it also likewise doesn't say in any city that abuts Costa Mesa.
Okay, and then you mentioned that 99% of patients do not have substance abuse issues? Or is
They
it
have a
that none
primary
of them,
mental.
that none of them are, or 99% of them are not, are you also implying that 99% of them are not in recovery? Or is just that they currently do not have substance abuse issues at time of admission?
Yeah, so 99% of them have a non-chronic mental health issue that is primary. Most of them don't even have a substance abuse issue when they come to us. So I guess what I'm saying to you is they're not being treated for that at all.
Sure, and it's not
So
unusual.
they could be in recovery from it.
Correct, and it's not, I mean, we've heard many applicants come before us, and it's not unusual for someone in recovery to have a co-occurring mental health disorder. So that doesn't quite surprise me. But what I'm a little bit confused about is when I was looking through your website, it very clearly states that at least half are, struggling with addiction issues. And so how does it go from, on your website, half of them are struggling with substance abuse issues and, of course, co-occurring mental health disorders, and they would not be able to afford their treatment unless you focus first on the primary mental health issue, right?
Why is that?
Because health insurance won't pay for substance abuse recovery, right?
Actually, that's not correct.
Okay. I stand corrected. That's not.
But most of our clients are actually pay. They have the means to be able to pay for treatment themselves. But to answer your question, I think it's a good point. But this is not the only facility that Insight operates.
Okay.
And so what I'm representing to you here tonight is that transitional living facility. That is correct with regards to that.
So
there is
on
an
your
absolute
website-
need for it, and that's our little niche.
So I'm confused. So on your website, you're saying that 50%, at least half are struggling with substance abuse issues, right? And then there's some that are struggling with your primary mental health disorders. And then you're asserting that in this home, specifically on this parcel, that 99% of them do not have any substance abuse or are not in recovery from any substance abuse issues.
Not that they're not in recovery, like I said, they could. That's not what they're here for. It's and I listed them. It's depression, it's anxiety.
Sure.
A lot of them have sexual trauma. It could be domestic violence, so they don't have a safe environment to go back to. So what we decided for the use of that property was that there is a need for housing for people who don't need sober living, because that's not what's going to meet their needs, but it's for they're struggling with this mental health issue, and so they need a community basically. And so that's what those 6 houses act like, is a mental health community where they can rely upon each other,
Sure.
where they start to integrate back in the community. So I don't know if you can actually read for me. I don't know what context you're reading something from the website in. All I'm saying to you is that it's not that we don't treat mental health, but this isn't a facility that treats. This is a facility that houses people with mental health.
Mental health
We're not
issues.
in the business of sober living. What we found is that there's plenty of sober livings that exist, and so to the extent an individual needs that, they can find it. But there was no services available for people with mental health that needed a place to go after residential treatment. And that's what this facility serves,
After residential treatment for what?
for mental health.
Oh, okay. There was never any residential treatment for substance abuse issues. It was always mental
The
health.
ones that are going to this facility, no, it's mental health. In fact, we have a place that probably provides a great majority of referrals, and they're an inpatient mental health facility. And so, in fact, I believe we have a couple of people that came from that facility, and they came to our transitional housing for that. That's why we're referred to so much, is because we provide something that you don't find in the community.
Yeah, and listen, I think what is not sitting well with me is the calls for service. When you look at the calls for service, there has been a call for overdose, and that was on November 28th, 2016. That's when your facility was in operation. And so I'm confused.
Let me explain. And this could just be, before I got into, this behavioral health industry, I also was, and I say this in a good way, but ignorant of a lot of things about mental health and the treatment of it. But a lot of people that we get deal with suicidal ideation. And one of the ways that they decide to take their life is through prescription pills. And so again, I haven't seen this. I even sent an email on Friday and said, if you have information relating to these complaints, I haven't had a chance to look into them, please send them to me. And as of the time that I filed that, no response whatsoever. In fact, it wasn't until I believe 5:07 tonight that the city sent me over a copy of a call log, which doesn't do me a whole lot of good at 5:07 once I leave the office to try and figure out what these are about. I can just tell you that overdoses, I mean, taking too many pills is an overdose. And it is, I mean, we see it all of the time. I told you we have a psychiatric stabilization facility, and we get people who are coming off of a 5150 hold or who don't necessarily meet the criteria. They take too many pills. So I guess you're relating overdose to drug and alcohol, and I'm telling you that this is what people with mental illness deal with, and the people who treat them, like Insight.
Yeah, and I don't dispute that. I know I have a very good friend that he recently committed suicide because he had a co-occurring mental health disorder and, you know, addiction issues, and it was the mental health disorder that eventually led to that demise. But I think that's all my questions for now.
Okay. Thank you, Commissioner Navarro Woods. Any other questions of the applicant?
Mr. Chairman.
Commissioner Zick.
Thank you. You mentioned at the beginning of your presentation that you're the only facility in Orange County providing the kind of service that you provide at this
The
facility.
transitional, yes.
Yeah. I'm assuming there's a much greater need in Orange County than the 30 individuals that you're servicing. So how do you think that need is being met?
I think it's not, and I think that's why we see the kinds of things that we see. I mean, just in the news recently, these are mental health disorders. I think we see them as homeless people on the streets. I think we see them as people who engage in mass shootings. I mean, I think everybody would agree that those people are probably struggling with some sort of mental health issue. People that don't have those issues don't go out and
Okay.
Excuse me?
Please, Ms. Parker, you either have to be quiet or leave the chambers. Thank you.
I will tell you this, if this city would give me another place in the city to put in more of these types of beds, I'm sure applicant would go for it in a second. It
Okay.
really is a need.
Thank you for your answer to that question. My next question, what's the average stay of your residents?
There are residents that stay up to a year, some of them 6 months. It really just varies.
And do you have a situation, I don't know if recidivism is the appropriate term, but do you have any residents that return to your facility after they've left?
Very rarely.
Okay. On the question of a reduction of the number of beds,
And can I qualify that just to add this? Part of the reason is people that are coming to live in the transitional living facility, they have a therapist wherever it is. They're getting treatment, and so they continue to do that and take their meds. And so I think that's probably why we don't have a lot of recidivism.
okay, so my question on the beds, you mentioned the number 25 beds, and when I look at the staff report, it indicates in order to get the one person per room, there's a total of 24 rooms, and so I would kind of think it would be 24 beds, not 25.
I did initially too, and then I read it a little bit closer. And so if you look at page 6, if you see under C, unit C,
Yes.
bedrooms, it says 2, but there's actually 3 bedrooms.
Okay, I understand your answer to that.
But if that's where the hangup is, 24 or 25, I would submit that applicant can reduce to 24.
Thank you. Mr. Chairman, I have a couple questions for staff, but no more for the applicant.
Okay, well, let's continue on with the applicant, and then we can move. I would prefer, well, we'll see how it goes. Vice Chair Harlan.
Okay, thank you, Mr. Chair. I'd like some clarification on the letter you submitted to the city. It's handwritten 23, dated February 1st, 2019. And in the middle of the first paragraph, we have a procedural posture and also some read it for you. It says hold. However, in late 2016, due to a substantial change in characteristics presented for treatment, applicants' use of the property changed. To me, that means you've been operating sober living facility previous to that, correct?
previous to, correct, that's correct.
And then somehow there's a change in characteristics of individuals. What does that mean?
Sure. So like I said, we're referrals that are coming in. What staff started to notice, and this is on the clinical side, and then it went up to the board, is that the individuals that were coming in were primarily mental health, had primarily mental health, and a lot of the housing rules for sober living were not compatible. They had medications that were not consistent with running a sober living and allowing them to be there. The staffing requirements, staff wasn't equipped to deal with those people that were coming in. And then we looked at what the need was for individuals, and we saw that there was this need that nobody was addressing. And it was really where Insight found its niche and has been operating ever since from. Yes, business, but also clinical. So the clinical was where this started from, is clinically seeing what the diagnoses of people were and how what we had could help. So all of the licensed staff that we have are all master's level and higher. They're not drug and alcohol. We don't actually employ not one drug and alcohol counselor because that's not the clinical population. It's not that we didn't have the expertise. What didn't happen is, I've been in this industry since 2008. I was doing litigation with the city of Newport Beach on their ordinance. And what I found was how these places were run. Somebody would go through a program. They'd have 1 day sobriety, maybe that. And then they'd open a sober living. And so originally, the applicant was doing sober living in a different way with professionals, with people who had master's level degrees and higher. So Insight actually has never employed, even while it was a sober living, a drug and alcohol counselor. It's just not what they did. But that was purely from what they believed were more like a professional staff that would treat patients. So it doesn't mean they didn't have the knowledge or the expertise. People with master's level and higher and doctorate, they know how to treat both. I mean, they're diagnoses. So they had the experience and the expertise. I'm just saying that we weren't employing drug and alcohol counselors. That the ordinance hasn't? Right, absolutely. I mean, the decision to change had nothing to do with the ordinance. It had everything to do with the population that was being served and a business decision as to where in this industry could Insight find its niche. And mental health and transitional living was one of them. It's why transitional living, there's always a supply of people who need it. There's just not enough.
Okay, Commissioners, Commissioner Russell, you have questions of the applicant?
Oh, there it goes. Okay, thank you. Just following up on the overdose question and medications, do the residents at your group home, are they individually responsible for their own medications? Do you have staff that oversees that?
No, absolutely, they're responsible. That's one of the key differences between 24-hour care and supervision and transitional living, is that these individuals are learning how to integrate back into the community and back into their home life. So they all have individual safes where they keep their medication, and they administer their medication on their own, which is why Insight, if it believes that there's some reason, if it feels that there's some reason to believe that they're not taking it or they're taking too much of it, then they will go ahead and do a toxicology screen on them so that they can see if that in fact is what's happening.
So the staff may observe someone behaving atypically, and then they'll do the tox screen, something like
Right.
that. I see. Okay, thank you. Other question I have, just on the logistics, do you have a policy on visitors and when they can be there and anything like that?
Yeah, actually, no visitors are allowed on the property at any time.
Okay, thank you. All right. That's it.
I'm sorry, we're having technical issues up here with microphones, so. Commissioner Russell, you're complete? You've completed your questions? Okay, thanks. Couple of questions.
Yeah, sure.
Is Insight, as you operate today, a group home?
Under the city's definition?
Yes. In your opinion?
That's what I've been told.
Okay, and do you believe that?
No.
Okay, so you don't believe you are a group home?
No, there's a lot
Okay.
of things I don't like about the ordinance, I guess.
Well, okay, and I appreciate that. So if you're, in your opinion, not a group home, why are you going through this process of seeking a reasonable accommodation under the group home ordinance?
Because one, like I said, I've been an attorney for 18 years, and one of the key principles is you exhaust administrative remedies before you seek help from the judicial system. So one, I'm exhausting administrative remedies.
Okay.
Number two, I was told by the city of Costa Mesa, I believe it was September of it was before that. It was early 2018, July, that if we did not apply for a reasonable accommodation, then staff would recommend denial of the CUP because of that. And so while all of this information was already contained in the request for reasonable accommodation, we've submitted additional information since then as the city's required it. But I'm basically playing by the rules. You say, the city said, do this.
Well, I'm just
We
asking
did it.
questions, that's all.
Yeah.
So the city's group home, the city ordinance defines group homes as a facility that is being used as a supporting living environment. Is that you? Is that
Yeah,
your-
yes.
Okay. For persons who are considered handicapped under state or federal law, does that encompass your residence?
Yes, it does.
Okay. A group home operated by a single operator or service provider, whether licensed or unlicensed, constitutes a single facility whether the facility occupies one or more dwelling units. Group home shall not include the following residential care facilities, any group home that operates as a single housekeeping unit. So the latter half doesn't apply to your facility, or does it?
You know, and I laid them out in my request. I believe a lot of things that happen at that property are things that a single housekeeping unit do. You know, to answer this question, in the denial, there's actually a statement that says that by definition, a group home cannot be, by Costa Mesa's definition, a group home cannot be a single housekeeping unit. And I think that that's indicative, well, not one of the issues I'm bringing up here tonight, which is constitutionality, but I think it's indicative of the fact that, and I didn't even address this for this reason, is that that definition of a group home was designed so that facilities like applicants and sober living homes could not meet that definition. And so it would be a waste of both of our time for me to get up here and to argue that they act as a single housekeeping unit, because the city has put in writing, which I was quite surprised of, that by definition, a group home cannot meet that single housekeeping unit. And I can actually tell you where you can find that at. Right here. Page 82 of the, you know how they hand wrote the numbers, but it's, I quoted it. The city states, and it begins with, on page 81 at the bottom, the application explains the benefits. The city actually stated, the operation of a group home is inconsistent with the city's definition of a single housekeeping unit. Group homes can't. They can't meet it, because that definition was in fact reverse engineered, so to speak, in order to come up with a definition that group homes couldn't meet. So no, according to that definition, we would not be a single housekeeping unit, although we do much of the things that The people next door who live in the apartments next door on both sides do.
Okay, so now going on to your contention about the ordinance with respect to noticing 500-foot radius versus the separation distance 650 feet point to point. I'm wondering if you would agree that if you are to determine whether or not there is another group home within 650 feet of a property, you essentially have to go around the compass 650 feet out all the way around and see. It's essentially a radius. You're drawing a circle. Would you agree with that?
No, I wouldn't.
Okay. Okay, anyone else?
Mr. Chairman.
Commissioner Zick.
So I have a question for the applicant, but a real quick foundational question for staff. Does an applicant have to I think the answer is no, but you tell me. Does an applicant have to establish that they are a single housekeeping unit to be able to get a CUP? Is that a barrier? I don't think it is. I just want to make sure.
The answer is no, it's not a barrier.
Thank you. Okay. So you answered a question from Vice Chair that got me very concerned. And his question was, as I heard it, do you consider your operation a group home? He didn't ask if you liked the ordinance. He asked if you considered yourself a group home, which means subject to the ordinance. And you said no. And I'll tell you why I'm concerned about that, and I'll give you my question. I'm concerned about that because if somehow through all of this process, you ultimately get approval to operate with the CUP and it'd be under the group home ordinance, there's a lot of conditions of approval. And if you don't think this applies to you, then I have very low confidence that you would feel compelled to comply with the conditions of approval. So I'm going to ask you the same question. Do you consider your operation a group home?
I will tell you that we will comply with whatever conditions to alleviate that concern. What I have a problem with, so I'm alleviating your concern, I'm saying applicant will comply with those conditions. I think it's semantics. I think it's, again, I was involved with the City of Newport Beach litigation. I don't like the wording of the group home ordinance.
I didn't ask that.
Group home to me is synonymous with sober living because that's why it was put in there.
Okay. Thank you for your answer. Thank you, Mr. Chairman.
Thank you. Okay, I will open the public comment portion of public hearing. Thank you, ma'am, very much.
Yeah, thank you.
And you'll have a chance to come up and rebut after public hearing, after public comment as well. Anyone wishing to speak to this item, please come forward. I would ask that you'd line up on both sides so we can kind of move through the speakers real quick, and each of you will have 3 minutes. Yes, ma'am.
Yes, as a client of Insight in July of 2018, I attended a residential mental health treatment. Upon leaving inpatient treatment in Arizona, it was recommended I continue treatment in the form of step-down transitional living. Instead of taking this advice from healthcare professionals, I went home for 3 months, ending up in a relapse, a mental health relapse, where I came back here to the Insight's I guess what they would call residential facility, and ended up in transitional living. There were only one opportunities, and Insight was the one that my treatment center in Arizona had recommended that had transitional living. Mind you that they don't just make recommendations in the state of California. That being said, after transitioning to Insight, I was given the chance for rebuilding my mental health and life with continued care, groups, therapy, and a community of support while also having time to begin transitioning back into daily life. Transitional living was crucial to my success and is the reason why today I am happy, healthy, working a full-time job and continuing to thrive each day. Insight is one of the few facilities and the only one that the inpatient treatment is a transitional living that supports those struggling with mental health. Without this, I'd be one less success story to tell today. And transitional living is hands down the best method to recover from mental health while having support as one continues to begin thriving in the community again. Thank you.
Thank you very much. Yes, sir.
Okay, 3 minutes. Thank you. I'm glad you're having this hearing. Appreciate it very much. My wife and I live at 2612 Westminster Place. I believe we're within 650 feet as the crow flies, which I worked in a civil engineering firm, and that's a very clear requirement. If you measured distances by the way you walked someplace, we would be in such disorganization in our communities, we wouldn't be able to lay out or survey anything. So you have to respect the very simple requirement, and it didn't say within Costa Mesa either, it just said 650 feet from another facility, similar facility. So I respect the simplicity of that requirement. I don't think it really requires any further definition. Okay, my first thing is why Costa Mesa? Why does it have so many of these facilities? Boy, what a question that is. And I went on, I did a little study, a little research. We have, according to this one website, 102. And I found another website where we have about 70. It's about 1 per 1,100 people. LA has 1 per, get this, 26,000 people. Okay, Riverside has 1 facility. They have 25 total, by the way, in Riverside. They have 1 per 12,000 people. Why is it we, in our coastal communities, it's pretty close, is 1 per 1,000 people? Why is that? Why do these companies seek out this property? I think there's a deeper insight into this that we're not even touching on. Coastal property is very valuable, and as an investment in real estate, I can tell you that this is where the increase in valuation is. Number 2, Santa Ana, that area, you know, they're going to build a little park right at the corner.
You have a minute left. That's all that means.
And it's for children. There's a lot of children in that neighborhood, and there's already at least three group or sober living homes. This facility I consider kind of the same quality. It has people that are having problems with their life, and I have nothing wrong with trying to get help. I mean, we have Fairview inside our community that does this, but it's on a huge piece of property that has a lot of distance between residences. Okay. I think also that this is a for-profit business, if I'm not wrong. These are residences. It's zoned for residences. It might be a little heavier density on Santa Ana, but that's okay. And there's a lot of traffic on Santa Ana. I'd hate to see another group facility with a lot more population increase go on that same property.
Okay, thank you very much.
Thank you.
Yes, ma'am.
Hi, my name is Laura, and before I start, I want to be very clear that I don't drink alcohol. I've never been an alcoholic, and I've never been a drug addict. I've never done a drug. I sought treatment for clinical diagnosis of PTSD. Before I came to Insight, I did 2 months of residential treatment in Arizona. I'm 33 years old and suffered horrific sexual abuse starting at the age of 6, some of which you've seen on the television with USA Gymnastics. For 27 years, I lived with crippling PTSD. Sure, I've got a 4.0. I've had a 4.0 my whole life. I was an elite gymnast, but I couldn't run from what happened to me for all those years. After I received care from one of the country's best residential programs, I was still in no condition to simply jump back into life. How did I know this? Back in 2009, I went to residential treatment for anorexia and relapsed almost immediately when I went back into the world. The relapse had nothing to do with effort or character or lack of heart. It had everything to do with not having transitional living options because I wasn't an addict. This is exactly what Insight gave me this time around. They gave me a fighting chance at the one life I have. All of my doctors, some of whom are the best in the world, said I must do transitional living. My heart sank when they told me I had 2 options in America. Option number 1 was in the same city where much of my abuse occurred as a little girl, and the other was Insight. Insight gave me my life back. There was enough structure around therapy and process groups for me to continue healing, and enough free time for me to experience that healing in the real world. 1 year later, I look at my life and I smile because I'm able to do the things I love doing. Volunteering with the homeless, volunteering at my church. I work full-time at an adoption and foster agency. I work with refugees. volunteering at my church, and finishing my master's degree. I know full well that I would not be walking in freedom and helping the people of this city, Costa Mesa, had Insight not been a place that I could go. There are no options for women like me who are not battling addiction, and I don't understand that. I don't understand why we would even consider shutting that down. Insight gave me the imperative step to step back into life so that I could walk in freedom. When you say no to Insight, you're saying no to a woman like me, a woman you want in your city, a woman that you want mentoring your teens and your kids, a woman you want to fight the homeless that you complain about and the families of your city that are broken. If I didn't have Insight, I wouldn't be alive. And my father's an attorney. We're a really well-off family, but it can happen to anyone, and it can happen right under your nose. I would have nowhere to go except for back to the city where my abuser lives.
Thank you very much. Yes, ma'am.
Hello. Chairman Arakel, thank you for your opening statement that handicapped people have the right to live in the city and in our area, and have the right to live and go to treatment as needed. I'm here with several of my neighbors that we have lived across from the buildings in question between 10 and 25 years. The client density. Smoking is not permitted in the facility, so therefore there's been a marked increase on people going onto the sidewalk and smoking and sitting on the curb. That is absolutely their right to do. It's just not good for the character of the neighborhood. Large items have been left on the sidewalk for, trash pickup, but their trash doesn't meet the Costa Mesa waste management conditions for pickup. Sometimes these items have been put into our yard across the street just because we have a convenient grass area. Visitors and car density. Visitors are not allowed on premise. However, plenty of visitors come to the sidewalk area and wait for the residents to come out. We have an issue with parking already. It's a crowded area. People will park in front of the hydrant, of our fire hydrant that protects us. And people have come into our driveway to wait for the residents to come out and pick them up. We've also had a marked number of Ubers. Because not every resident has a car, but there's lots of Ubers, which is a right, but it does add to the crowding. Residential character, I would say that a lot of the non-facilities are, a lot of people in the home, in the neighborhood either own or are long-term renters who are invested in the community and want to make a difference. I would argue that the on-site managers are probably not invested in our community and upholding the standards, other than this is their job, they are there to do that. Also, I'm a little dismayed at what, and forgive me for characterizing it this as, is the playing kind of fast and loose with some of the words, kind of rebranding a business decision between non-chronic mental health issues and sober living from substance abuse. It seems like we're playing with the words, much similar to how Botox was advertised originally for migraines, and then, oh, wait a minute, we're going to make a lot more money if we advertise it for facial enhancement. Thank you.
Hi, I'm directly across from this facility and some of our concerns, and we're exactly as the woman stated over here, so I'm not going to reiterate them. As someone who actually works in treatment, and I was a program director at New Directions for Women that is actually a block or two away, I think that the big problem here isn't that there are treatment facilities or sober livings or group homes in our neighborhood. It's the quality and the management of the sober livings. If you're to look into this facility that they're proposing, I feel that they're trying to say that it's out of compassion for mental health clients, when in reality it's a business that is getting paid by insurance to say that it's a dual diagnosis facility treating mental health primarily rather than just substance abuse. The owner, as mentioned on the website, or CEO, Mary Helen Bettafuco, I know was violating codes in Newport Beach. There was a legal fight and they lost state licensing in 2012, having their license revoked for not destroying meds properly, not maintaining patient confidentiality in death investigations. I don't feel that this is a very well-managed facility. There are ambulances there all the time, kids ODing, working in the community. I know of clients that go to this facility. I know of the quality of care that's being delivered. I don't feel it's being properly managed. There is loitering. Today there was an ambulance taking someone away on the property at 4 o'clock, I believe. And our concern is really just that quality of care. You know, New Directions for Women, ACUA, none of them are causing any issues for the community. Our street has a lot of young kids. You know, we're concerned just about the safety of the community and the screening of the individuals they're allowing. The lawyer had stated that they're taking clients directly off of 5150 holds. So that's a 72-hour psych hold, and they're saying that they're stepping them down immediately to this residence. That's the next level of care. So that would have to be a residential or a partial hospitalization program. That makes no sense. They're telling us it's a group home where they are administering medications and that they're not facilitating groups or have offices for therapy. If that's the case, then they're violating state code, because I don't understand how they could run a residential facility without facilitating groups and one-on-one therapy on site. That wouldn't make any sense. Therefore, it is technically a sober living or a group home, where they're directly taking clients that are stepping from a very serious 72-hour hold or inpatient hospitalization. And again, so that is just our concern, the quality of, you know, people working there and the clients walking around on the street or not being managed properly. Thank you.
Thank you. Yes, sir.
Thank you guys for the opportunity to speak here. I live off of Santa Ana or on Santa Ana, within 600 feet from this location. As the gentleman mentioned earlier, there is going to be a child park coming there from the OC Public Works that is going to be part of Costa Mesa, is going to be responsible for maintaining that park. That's been in progress for about a year and a half. First community meeting in June, the last one, or in January, then the last one May 30th. And then this park going to be there within, it's about 575 feet, according to Google, going and measuring it from the actual location to there, being on the corner of University and Santa Ana. That's supposed to be slated to be open in June of 2020. That location was strategically picked to provide additional opportunities for families to come into the environment, people that are invested in the community, people that want to thrive in the community, people that want to raise families from a long-term basis in that community. We have challenges on this street specifically about speed and traffic and overcrowding and information. Since 2015, there's been over 12 reported accidents by the Costa Mesa Police Department on the intersection of Santa Ana and Mesa alone. This is just the city of Costa Mesa. This is not Newport Beach. This is not the county, because we all know the issues between that intersection and what's going on between Newport Beach, Costa Mesa, and the county of what's going on. We have to control the flow of traffic. What's going on, the last thing we need is more transitional people coming into the situation. We applaud folks of trying to deal with mental illness and providing opportunities, but we need people invested in our community. In this particular area where it's a high traffic, it's an artery to the neighborhoods, it's an artery to the Back Bay, it's an artery to the highway, that we control what happens in this area, and it has to come from the residents who live on this street, who have an invested interest in the safety and welfare of our families. I have a 6-year-old daughter. We want to go to that park, but we don't want to go through a crowd of people. We don't want to have to fight for parking when you go down to that area, because there needs to be adjustments happen. It is an overcrowded street as it is right now. It needs to be addressed where people will have permanent opportunities to live and thrive in the community, and make sure that that happens. We appreciate the consideration and want to provide opportunities for folks to get help, but just not another one in my backyard. Thank you.
Thank you. Yes, sir. Good evening.
Good evening. Thank you for allowing me the opportunity to speak tonight. I am the managing member of the LLC that owns the property. Couple of things. One, I hear everybody in this room as an owner of property. I want to make sure that, our property, that we're good neighbors, that people feel comfortable, that, I have a few properties here in Costa Mesa. I love the east side of Costa Mesa. And I want to be a good neighbor. So I hear what everybody's saying. I do want to say, though, that since 2015, that Insight has been a tenant at this facility, and I have specific experience myself dealing with a family member with mental health illness, and when there was an opportunity to rent to them and see the kind of things that they do, I thought it would be a worthwhile endeavor. And they've been a very, very good tenant. I know that when there was, when there was any type of code enforcement issue, anything that came up, they immediately were on it, made changes, made sure that they complied. And I, as a landlord, and I, as a owner of property, want to make sure that we are in compliance with the city ordinances and that we're doing everything the right way, and that we're as good a neighbors as we could possibly be to everybody in the community. At the same time, I just feel so strongly about some of the things that they're doing. And just really one quick story. A few years ago, when I went to go down to the property to inspect the property, somebody, I guess they were about 23 or 24 years old, came out to me and said, "Do you own the property?" I said, "I do." And he said, "Well," he goes, "I want to tell you something." And he started crying. And I said, "What?" He goes, "This is the nicest place I've ever lived. And I think because of this, I think I'm going to make it." I have a son who suffers from mental illness too, and I'm telling you that it really grabbed me. So I do hope there's a way that we can work with the community, that could be good neighbors, and also have an opportunity to provide some of the services to the people who really need it. And I hope that we could do it in a way where we bring everybody together and find a real way to make it work. Thank you.
Thank you, sir. Yes, ma'am.
Hello, I'm a resident. I live approximately 600 feet from where the applicant is asking for the permit. Anyway, I would just like to point out a few things. I wanted to ask how much the monthly residential rent, like per resident, to live in this facility would be, and how that compares to the resident in the resident rent in the surrounding area. I'm hearing that this girl, I'm so glad that you did well, but your family was well off. They could afford to send you here. That's great. We have two people that spoke from Arizona. I don't see how we're benefiting the residents that need help in our community by flying people in from other states. I'd like to help the residents in our community. I live in the community. I bet you I couldn't afford to stay in this mental health facility, and I'm mentally ill. If I had a breakdown, another breakdown, I couldn't get in. So, I want you guys to think about this. This is a nonprofit business. I also think that the switch to mental health is a direct result of the crackdown in insurance on sober livings and other treatment facilities. We all know that there's been human trafficking that's gone on with rehabs and sober livings. As a result of this, insurance companies are cracking down on these facilities. If I was in the business, I'd switch to mental health too. So also, I live close. This is on my dog walking path, and I don't walk my dog by myself anymore because of interactions I've had with residents of this facility, whether it be looks, words, gestures, "What are you looking at?" that kind of thing. It's scary to have, in your little street. I've lived here for 19 years in my house on my street on Santo Tomas, and I never had that problem before. We also never had mail theft before that. Before the last 4 or so years, 5 years, we never had, we did have some car break-ins, but it's increased. And the parking has become a much bigger issue in the last few years, so that's all. Thank you.
Thank you. Yes, ma'am.
So first of all, I'm sorry I laughed, Mr. Derrico, but I've been at this a long time, a lot longer than you.
You still don't get to disrupt the meeting, Ann, so
I'm
proceed.
sorry if I laughed. There were quite a few people
Proceed,
laughing.
please.
And by the way, this is one of the worst smoke and mirrors, double speak I have heard since I've been at this, which is a lot longer than you. Sorry if I laughed. First of all, this young lady that just spoke, and well, first of all, my heart goes out to anybody dealing with these problems, anybody. But if anybody knows anything about addiction and recovery and everything, how many times have we heard this? There's frequently an underlying diagnosis. You've all heard this 100 times, right? I hope you're listening. So anyway, first of all, is this property on a triple net lease? How much money is the owner of the property actually making off of this business? I have been by this place so many times. I've spoken to the neighbors around there. This is not a well-run house. And I don't know if you read this, but when people have mental challenges like this is so serious. Look at what they require for their house manager. To be 21 years of age, have a high school diploma, and 40 hours of classroom instruction. Excuse me, how in God's name does that qualify you to handle the difficult situation a lot of these people are in? I am appalled that this is, they do have a life scan. That's a good one. A lot of these operators don't require that. I'm just shocked. Now, first of all, I just want to go right here quickly because most of it was covered beautifully by the surrounding neighbors. But they didn't mention this. There's a lot of white vans that pull in. It says they have a large driveway. Are you all reading this report? Did any of you go look at this property? It's a long, narrow driveway. You, of course, Ms. Woods, thank you. You always check on these things. They back out. They pull in and they back out. I have had to stop, screech brakes on so many times on Santa Ana because they are backing out the driveway. They don't have mirrors or some way they could see the oncoming traffic. They don't care. They just pull right out. I think this is one of the worst houses in Costa Mesa, and also this is over-concentration. Look at how many people are on this property, and you think they're going to honor any kind of a lowering of the population? I doubt it.
Thank you. Yes.
Well, I've been waiting for quite a while to come up here, so my phone is pretty much just dead by now because I was on their website. And as the last speaker mentioned, both her and I have been at this for years now. And it's not the point that we're not compassionate to individuals who've had difficulties throughout their life and situation that requires them to seek these facilities. The problem is that our city has lost everything in a sense of its style. There is one on literally every street. So the way that the ordinance was constructed was a 650 separation no matter what. The problem with the wonderful lady representing the applicant, the attorney, is they're really good at spinning it. So they're not treating them. The individuals get to take their own medicine, and if they notice that they took too many, then they will accommodate them. Sure, they'll 911 and have Costa Mesa paramedics come and pick them up. That's an accommodation. It's out of control. We've said it. We've lived it. It's impacting the city in traffic. It's impacted the city by services provided. And as other members of the community mentioned, these aren't people that are vested in the community. I've been in Costa Mesa since '89. I went to Orange Coast College. So that actually takes a little before that. But the point is that they're here for 60 days, 90 days, 120 days, and then they move on. With some of the younger ladies, and I've got plenty of experiences with the guys on Ohio Street behind Circle K, they don't intimidate me. They can look me down. It doesn't matter. I'm a long-term guy here. For the ladies, it's a whole different story, and I get it. My wife won't go out unless she's got the 3 huskies with her. So enough is enough, and we've crafted this ordinance in order to mitigate some of these damages. So please, let's do the right thing. Thank you.
Okay, anyone else? Okay, I will close the public comment portion of the hearing and ask the applicant to come back up if you have any additional comments you would like to make. Yes, ma'am.
Thank you, Chair. Just a couple. There was some public comment about, and I believe it was some engineer who said that it's obvious that you would measure in a radius. And I just want to say again, if it was so obvious, then section 13-322 would say radius. And if it was obvious, then section 1329D1 that talks about mailing notice wouldn't have to say radius, because everybody knows that when you're measuring point to point, that you do a radius, and they could have just left it out of 13-29. They didn't. They put it there. They didn't put it in 13-322, which there's a reason they didn't. Also, somebody mentioned ACUA and how reputable it was, and I would say because ACUA, even though they say they do, they don't treat mental health. They're actually the ones calling us all the time, and so I'm glad that a reputable place is calling to refer to us for their mental health transitional living. The 5150, in case it was confusing at all, is I said that Insight has a number of facilities. One of them, as I mentioned, is a psychiatric stabilization facility. So the people who don't meet 5150 criteria or are just coming off of a 5150 hold is at our psychiatric stabilization facility. That is not the facility that is here before you tonight. The only reason it was mentioned is because we're talking about expertise, about the website, about other people who are treated with substance abuse issues. Insight has a number of facilities. This one tonight is about transitional living for the mentally disabled. I also thought it was interesting, someone brought up about the number of accidents, and I absolutely agree. I can't tell you how many times we get the Orange County Sheriff coming out and also the police department to ask for the footage from our surveillance videos, because one of our cameras, in fact, recently I instructed staff to change the angle of one of the cameras so that it could even get the mailboxes across the street because of the amount of mailboxes that were being broken into. And so the police have come to us and asked for our surveillance video, which we have given to them. That's because the people that are breaking into the mailboxes and the people that are speeding and getting into accidents are not the people that are living in this transitional living. Lastly, I heard about Ubers and calling Ubers and neighbors parking in front of your house and smoking. Smoking is not disallowed at the facility. What I said is you don't have the number of people smoking that you do at sober living homes because they're not giving up one addiction for another. But they are absolutely allowed to smoke. We have certain areas where they're allowed to smoke, so they don't need to go out in front of the property and sit on the curb like I've heard to smoke. But more importantly this, I really wish that there was a public hearing so that I could come and complain every time the house next door to me got somebody new moving in or somebody down the block, because people call Ubers all the time. That's what Uber's for. People get rides, and they get rides to places. So the fact that people are calling Ubers, I'm not really sure how that's relevant, and also why people within the city think that they need to complain about the fact that people are calling Ubers. Happens all the time. If you don't have any additional questions, I don't have anything else to say.
Thank you, ma'am. Commissioners, any questions of the applicant? Okay, thank you very much for your time. I will close the public hearing. Is there any further questions of staff?
Mr. Chairman.
Commissioner Zick.
So I've got several. With regard to our ordinance for group homes and its intent, does it talk or speak to at all whether we are trying to favor a treatment of Costa Mesa residents versus any other population?
The ordinance speaks in general of residential neighborhoods. I'll do a little deeper dive and let you know if I see anything more specific.
Okay. And I think I know the answer to this one, but I just want to be sure. If somehow the reasonable accommodation was granted, would there still be a CUP and associated conditions of approval? In other words, granting the reasonable accommodation doesn't waiver the CUP requirement, correct?
It depends on what portion of the request that the commission granted. There were two requests. It was either to waive the separation conflict or to consider this facility not subject to the group home ordinance, so it depends which one.
I was referring to the separation requirement.
Yes, if
Yeah, okay.
the separation requirement was waived, then the CUP requirement would still apply.
Okay. Still on kind of this idea of the separation requirement, I'm wondering if there are other applications for group homes that the city is currently processing that are within the 650-foot radius of this property.
I don't believe so. Not the ones that we have present applications for.
So to say it another way, if this group home application was denied, that would not open the door for another group home application to be approved because this would not be within the 650 feet of it.
First, the facilities that are state licensed are still facilities that are considered in any separation conflict analysis. Anything else would be a sort of case-by-case basis analysis that we do for each application.
Okay. Just kind of taking these questions in order. So there was an indication from the applicant that they would, and I might be saying this wrong, but they would somehow stipulate that their use would never revert to sober living. So my question is it possible that a CUP could be approved for this group home use that would include a prohibition against use as a sober living home?
Yes.
Okay. With regard to state licensed facilities, so clearly the existence of those state licensed facilities is what raises the separation requirement problem with this applicant. Can there be other state licensed facilities that just open up without our approval? Could Costa Mesa become, more than it is already, a concentrated area of state licensed facilities without our being able to control that?
Facilities that are state licensed with 6 or fewer are permitted by the state without regard for the city's zoning regulations.
And over 6?
And over 6, we have requirements that apply, either a special use permit or a conditional use permit.
Even if it's state licensed?
Yes.
Even if it's state licensed,
Okay,
yes.
thank you. So I'm interested, I think my engineering background peaked on this question of radius and point to point. So it's not so much a question, but I don't mind speaking on this. Radius is a property of a circle. It's not that's the context of using that term. And the 500-foot radius that the city uses and speaks to is a method of capturing a circle around which contains all the people that need to be notified of particular actions the city is contemplating. In other words, the radius identifies how big a net you're casting. It's a circle. This requirement of 650-foot separation doesn't necessarily require you to draw a circle unless you're trying to identify the entire perimeter of area in which you're looking for other group homes. But when you know there's an existence of a group home, as you do in the case of these two state facilities, all you need to do is measure a line, point to point. It's either less than 650 or it's more than 650. So that's not a question, but thanks for. Do we have a requirement on the group home ordinance that differentiates between profit versus not-for-profit?
No.
Okay. And with regard to license verification, there was a speaker that, as I heard, raised some question or concern about the proper licensing and operation of the facility. So let me ask the question this way. With regard to regular doctors in the city, dentists and regular medical doctors, does the city have any requirement where we go and verify that they have proper licenses, medical licenses?
No.
Okay, so it wouldn't surprise me then if you'd give me the same answer, whether we would verify any medical licensing status of an operation that dealt with drug abuse recovery or any of these other group home populations.
So we do not have a process by which we verify specific medical licenses for these facilities or others. We do have operators permit requirements that apply, and there are specific submittal requirements related to that permit, and we do verify the information provided by the applicant.
Okay, and then following up on the earlier question I asked, and I'll expand on it a little bit, since the applicant indicated that they would love to be able to expand their operation in Costa Mesa and serve additional people. My question was whether these sorts of group homes would be allowed to operate in, if we had institutional zones in the city.
We do have institutional and recreational zones in the city, but all of them require approval of a master plan before the Planning Commission to establish any kind of a development on the property.
The group homes are identified as a permitted use subject to that master plan approval.
Okay, and that's more of that's still a discretionary approval, but it's more of an approval by right than it is by a community consensus?
It's still a public hearing process that goes before the Planning Commission, almost like a conditional use permit.
Okay, thank you very much. Thank you, Mr. Chairman.
Okay, anyone else? All right, very good. Commissioners, are there any final comments or motions? Okay, I will go ahead and make the motion, and then I'll have comments if there's a second. Move to adopt a resolution upholding the director's denial of the request for reasonable accommodation RA 19-06 and denying conditional use permit PA-16-63. And I've made the motion. Is there a second? I think I made the motion. Yes, okay, and they're seconded by Commissioner Navarro Woods. Any comments, commissioners?
Yes, Mr. Chairman.
Yes, sir.
It's pretty clear to me from the staff report and to some extent the public testimony, but largely the staff report, that this application does not satisfy all 8 necessary findings which are required to approve a reasonable accommodation. That said, the applicant seemed interested in modifying their operation in an attempt to come into compliance with several of the requirements. And I think I'm going to make a substitute motion as a result of that. And my motion is to continue this item to give staff an opportunity to work with the applicant to resolve several outstanding conflicts which the applicant appears amenable to address, including the occupancy load of the property with regard to beds and parking, the code requirements that relate to landscaping and construction permitting. And that's my substitute motion.
Is there a second? Okay, that motion dies for a lack of a second. That brings us back to the original motion. Any comments on that motion? Commissioner Navarro Woods and then Vice Chair Harlan and anyone else?
You know, I just
Commissioner
wanted
Russell,
to
are you? Okay.
Am I on? Okay, sorry.
Yes, you are.
You know, I'm used to the green light. I just wanted to thank staff for doing a great job of providing supporting facts for their findings. I think they did, it was very well done. For me, this was a very easy decision, especially when the applicant acknowledges that they are a group home and therefore subject to the group home ordinance. That's all. Thanks.
Okay. Commissioner Russell? Yeah, it's not coming on, is it? Okay. Oh, there it is. It's on
There it
now.
is. All right, thanks. This was a little bit challenging for me from the perspective that I'm always advocating for supportive housing for people that are in need and in recovery and mental health consumers. And yet I kept coming back to the whole issue of it being a group home and the issue of there being a lot in that particular neighborhood. If this was in a neighborhood that was in where there wasn't the perimeter issue, I'd be like, yes, we need to do this. But under the circumstances, I can't do anything but support the motion. So that's just what I want to say. I mean, we need to continue to look for affordable housing and supportive housing and working with people that are coming back up into permanent housing. That's all. Thank you.
Thank you, Vice Chair Harlan.
No, only Carlos is working.
All right.
First of all, I want to thank the people who testified tonight with regard to their challenges in mental health issues. I know it's not an easy thing to do in a public forum, and I did sincerely appreciate those words. Having said that, though, for me, like some of my colleagues, this is a very simple land use issue, and it's been said a number of times tonight that the purpose of our ordinance is to preserve the residential character of our residential neighborhoods, but also to uphold the federal and the state legislation with regard to housing and disability. And to me, our ordinance is a policy that reflects the balance. And the heart of that is this 650-foot separation limit that we have. And I don't see any reason to deviate from that tonight. It seems very clear that there is a separation conflict that I don't see how the applicant can overcome despite their creative arguments. I feel like it's necessary to continue to uphold that. So I'll be supporting the motion.
Okay, thank you. And I will just add that to me, this is a very straightforward application of our current ordinance. I think the applicant acknowledged that they are a group home as defined as this. A facility is being used as a supportive living environment for persons who are considered handicapped under state or federal law. And therefore, it falls under the provisions of our code and can't escape the separation requirement with respect to both the reasonable accommodation and the CUP. So for that reason, I can't, I have to support the denial of the zoning administrator. So I will call for the question. No votes? There we go.
That motion carried 5-0 with Commissioner Colbert and Commissioner Torje absent.
Okay, and that decision will be final in 7 days unless appealed to the City Council. I'm going to ask if we can take about a 10-minute break, and we'll be back at 8:30. Okay, we're back in session. If we could please take our seats, bring the meeting back to order. It is, thank you. Okay, Julie, public hearing item number 2, please.
Public hearing item number 2. Planning application 19-10 for Audi Fletcher Jones automobile dealership at 1275 Bristol Street. This is a call to report any ex parte communications.
Okay, commissioners, any communications to report? All right, seeing none, Mr. Lee.
Good evening, Mr. Chair and commissioners. The subject property is located along Bristol Street. Even though we at staff regard Bristol to be a north-south street, even though it's technically going east-west. So basically, with that as orientation, immediately to the north of the subject site is the new Ganal lumber facility, which relocated from this site in 2018. Immediately to the south is Bristol Village Plaza, which consists of several drive-through restaurants and other uses. To the west, across Bristol Street, is an existing apartment complex, as well as restaurants, mini storage, and various office uses. And finally, across the California State Route SR 73 is industrial buildings. So this next exhibit shows the zoning designations for all of those affected properties. The red for the subject site signifies C2, which is general commercial. To the north and south is C1, local business district. Also across the street is C1 with the exception of the apartment complex, which is zoned R2MD. And the industrial uses across the SR 73 is PDI, which is planned development industrial. Here are some site photos, basically looking at the site from Brookhurst Street. The photograph at the far left is basically the northerly boundary of the property, adjacent to the new Ganal lumber site. Basically going southward as you go to the right across the photographs, finally ending at the southerly portion of the site where the existing freestanding sign is. The project before you this evening is the construction of a new 50,971 square foot, two-story auto dealership, which is Audi Fletcher Jones. The use includes the sale and lease of new and pre-owned vehicles, as well as vehicle repair, 343 on-site parking spaces, including vehicle display, vehicle inventory, and employee and customer parking will be incorporated all on site. Site landscaping will be incorporated both around the perimeter of the site and throughout the parking areas. And finally, there will be improvements within the public right-of-way, including a new sidewalk, and street tree removal, which was separately approved by the Parks, Arts, and Community Services Commission on June 27th, 2019. There are actually 3 applications that are part of this proposed development. The first is the conditional use permit for the automobile dealership itself, and 2 variances. The first variance is a request for variance from building height. Code allows a maximum permitted building height of 30 feet, 39 to 44 feet is proposed, and variance from landscape street setbacks from 20 feet, minimum required, to 10 feet proposed. By way of background, from 1998 to 2018, this site was occupied by Ganal Lumber. The Ganal Lumber received an entitlement in 2015 to basically relocate from this facility to the property immediately abutting the site to the north, which is addressed as 1100 Bristol Street, which of course was approved by the Planning Commission that year. And Ganal Lumber relocated from the site, from their original site to this new site in April of 2018. In May, Fletcher Jones Motor Cars acquired approval of a minor conditional use permit to use the current site, the former Ganal Lumber site, as an interim storage for up to 150 vehicles for their interim dealership, which is located further to the south at 375 Bristol Street in the old Bristol Street Autoplex development. And finally, in February of 2019, this application that is before you was filed by the applicant. This exhibit shows the proposed development. Once again, orienting to the north is basically where the apex at the left-hand side would basically be towards the north of the site, towards the south of the site, adjacent to the shopping center with the drive-through takeout businesses would be to the right-hand side of this slide. Bristol Street is going along the bottom here. You see the Santa Ana Delphi Channel as well. What this exhibit is showing is it's showing the proposed landscape layout. The circle signifies the proposed trees that will be located throughout the project site. Also, color-coded are the various parking areas. The red signifies the areas of the parking that will be used for the display of vehicle inventory. Shaded in green are the areas of the parking that will be used for storage of vehicle inventory. Highlighted in yellow are the areas that would be used for customer parking. And finally, in blue are the areas that would be used for employee parking. I should also point out that on the second floor of the service building is a parking slash deck that will be also used for vehicle inventory. Basically, to further describe the uses that are proposed, you'll see a couple of things here. You'll see where it's identified as auto dealership building. As I mentioned, it's actually a 2-story building. On the first level is the showroom area and also the area where the service advisors would be taking the cars that are coming in to be serviced. As you can see, basically along the Bristol Street frontage, there are 2 new driveway approaches. The driveway approach to the northernmost part of the site will also contain a new freestanding sign. Basically, customers bringing in their vehicles to be serviced would basically pull in underneath this porte-cochere, where the service advisors would take the information, take the vehicle back behind the rear portion of the building, the first floor of the building, for service, which is where the service bays and car washes will be located. Now, this area is shaded green because, as I indicated, on the second floor is additional storage space for vehicle inventory. On the second floor above where it's labeled auto dealership building is where the administrative offices will be located. This includes basically areas where the trainings will take place, break rooms, things like that. All of that would be on the second level. And as I indicated, the first level will be primarily for the customers that are bringing their vehicles to the site, either considering purchasing or bring it in for repair. This next exhibit shows two things. Highlighted in red at the top of your screen is the area where vehicle transport trucks would enter off of Bristol Street and basically load and unload their vehicles, basically in the red shaded area. Because the amount of traffic and the speed of traffic along Bristol Street, we are recommending as a condition of approval that all loading and unloading of vehicles take place on site and not within Bristol Street. Highlighted in yellow is the existing Mesa, Metropolitan Water District of Southern California feeder line. It basically consists of a 36-inch diameter steel pipe, which is located underground and is covered by a 15-foot wide easement. This easement will not allow any structures to be built over it, which is why the proposed new building is located outside of it. And it also provides a justification for one of the variances that is being proposed this evening, which I'll describe later in this presentation. This exhibit shows the elevations of the proposed building. The architectural design is contemporary design. It is consistent with the current product branding that has been approved by Audi. It basically consists of painted cement plaster walls with horizontal and vertical veneers that you see here. The major architectural element is glass glazing and corrugated metal panels with a metallic finish. What you're seeing in these two images is the dealership as the bottom elevation is as you're looking from the parking and vehicle storage area towards the site, basically looking south. The one at the top of your screen is what you would see if you were looking off-site towards the north from the budding Bristol Village Plaza. Both elevations show the proposed building as it would look from Bristol Street. Basically, what you see at the bottom here is the continuation of the building that is cut off here. Basically, what you're looking at here is a proposed maximum building height of 39 feet to the top of the main building, and then an additional 44 feet to the very top of the equipment screen. As I mentioned, the maximum height allowed under code is 30 feet, which is necessitating the requested variance that is before you this evening. When it comes to making findings for variances or any deviations from code, there are specific findings that have to be made that is consistent with both city and state codes. The first being that there has to be special circumstances applicable to the property wherein the strict application of development standards deprives the property of privileges enjoyed by others in the vicinity. The deviation granted will be subject to such conditions that will assure that the deviations will not constitute a grant of special privileges inconsistent upon other properties in the vicinity. And finally, the granting of any variance or deviation will not allow a use, density, or intensity which is not in accordance with the general plan designation or any applicable specific plan for the property. So with regards to the requested landscape setback, As I indicated, 20-foot landscape setback would normally be required under code for new development. 10 feet is being proposed. In this instance, the subject site is located between the two properties that you'll see in the next slide that were granted setback variances, both for the new Ganal lumber in 2015 and for the Bristol Village Plaza to the south of the site back in 1977. Also, when the Planning Commission considered the variance for the new Ganal lumber back in 2015, it was noted that there are also several properties directly across the street on Bristol that also have less than 20-foot landscape setbacks. Finally, as indicated in the landscape exhibit, there will be proposed trees and vegetations that will provide a visual break from the public right-of-way, similar to what is already existing on the street. And therefore, the deviation will not constitute a grant of special privileges to this property, basically because of the existing landscape setbacks on the abutting commercial properties. And of course, because the property is designated under the general plan as a general commercial use, and the use is commercial use, it would be consistent with the use, density, and intensity of the general plan designation for the property. This is a Google map exhibit that shows the new Ganal lumber to the north here. The variance in question was not only for the landscape setback along Bristol, but also was for a building setback for this large shed here. So literally, as you're going down Brookhurst Street as it exists today, this building has a 10-foot setback, which was granted through the variance back in 2015. Going to the south of the subject property, like I said, a lot of these businesses that you see here, when it was developed, it was also approved with a variance back in the 1970s. So even though the buildings have the proper setback, the landscaping setback along both Bristol and Red Hill are 2 feet. As a matter of fact, the McDonald's restaurant here that was remodeled a few years back basically maintained those setbacks. With regards to the setback of the new building, it should be pointed out that the new building will have a code-compliant building setback of 36 feet and 2 inches. Also in this Google exhibit, you'll see that there are several buildings on the opposite side of Bristol Street which also do not have either a 20-foot building setback or a 20-foot landscape setback. They're basically at 10. And this photograph shows two of the properties in a little bit more detail. In fact, if you look at the photograph on the left, you'll see that going down the street, several buildings basically have closer than a 20-foot setback. And then the area between the building and the public right-of-way is signage and/or landscaping. So with regards to the variance from the requested building height, as you saw in the earlier exhibit, there is that water pipeline and easement that's bisecting the subject property, and that creates a justification for the deviation from the maximum building height requirement, because basically that puts a restriction on the building footprint that can be built on the site that is not bisected by that easement. So that basically results in a more vertical type of building profile than would normally be allowed. The deviation would not constitute a grant of special privileges due to the existing easement and the fact that the shed that you saw in that air photo also has a variance from a maximum building height, the one for the new Ganal lumber. And once again, because it's a commercial land use designation, it's commercial use, it will not create a use density or intensity that is not in accordance with the city's general plan. With regard to the conditional use permit, staff is recommending several conditions of approval. Many of these we routinely incorporate when we are working on conditional use permits for automotive dealerships. The most recent one being the Cadillac dealership on Harbor had many of these similar conditions of approval. Obviously, public address system with outdoor speakers are not allowed. And also, in the event complaints are received related to parking problems, the operator would be required to institute whatever measures are necessary to minimize or eliminate the problem, including maybe reducing the amount of vehicle inventory on the site, employees, or providing off-site parking. Employees would not be allowed to park on any nearby residential streets, and the operator will also assure that adequate parking for customers exists on site. Also, a standard condition of approval for auto dealerships is we do not allow test driving of vehicles on residential streets or within residential neighborhoods. We've incorporated a condition of approval that vehicle display areas shall not encroach into the front landscape setback area as approved, and as that landscape area will be planted with trees, that will not be an issue. And as you saw in that earlier exhibit, loading and unloading of vehicles will be required to be done on site and not within Bristol Street. And once again, as per that landscape plan, the landscape setbacks along Bristol Street will be planted with trees and vegetation consistent with the approved landscape plan. And I would also like to point out that in creating the landscape palette, specifically along this street frontage, the developer is proposing to match the landscape palette that was approved and planted for the new Ganal lumber. So basically, coming down that side of Bristol Street, you'll have a consistent landscape palette going across not only Ganal lumber, but the Audi dealership as well. And finally, because of the proximity of the apartment complex across the street, the site lighting will be required to be designed to minimize light or glare on residential properties. With regard to the street tree removal, the applicant is proposing work in the public right-of-way, which would involve removal of the meandering sidewalk and also the 5 existing street trees, and constructing a new standard sidewalk at the back of the curb along Bristol Street. As I mentioned earlier, the street tree removal was reviewed and approved by the Parks, Arts, and Community Services Commission on June 27th, 2019. And the commission at that time determined that in order to offset the removal of those street trees, the applicant was required to provide 15 new trees to the Public Services Department, which were delivered to the city on August 2nd, 2019. In accordance with the California Environmental Quality Act, an initial study, mitigated negative declaration, was prepared for the project by a consultant that was selected by the city. The document was made available for a 20-day public comment period beginning on June 25th, 2019, and it ended on July 15th, 2019. Public comments that were received during that period were reviewed, and response to comments were provided, which are in your packets this evening. Basically, what the ISMMD did was it evaluated the environmental effects of the project, and it identified specific mitigation measures in the areas that mitigation measures were deemed to be necessary, specifically biological resources, cultural resources, tribal culture resources, and hazardous materials. So basically, in order to ensure that the mitigation measures are properly implemented, a mitigation monitoring program has been prepared, a copy of which is actually included as an exhibit in your approval resolutions this evening for the proposed project. And with the implementation of those mitigation measures within that mitigation monitoring program, any environmental impacts will be reduced to less than significant levels. Therefore, staff is recommending that the Planning Commission adopt a resolution to 1, adopt the initial study, mitigated negative declaration for the project, including the mitigation monitoring and reporting program, and approve planning application 1910, subject to the conditions of approval and those mitigation measures. This concludes my presentation. I can respond to any questions the commissioners may have. Also in attendance this evening, as I mentioned, is our consultant who prepared the CEQA document that is before you this evening. And of course, the applicant's representative and the architect are also present to respond to any potential questions.
Thank you very much, Mr. Lee. Commissioners, are there any questions of staff?
Mr. Chairman.
Commissioner Zick.
First question, just a minor bookkeeping question. So on the first page of the staff report, it indicates this is approximately a 4.9 acre site. Page 15 says it's a 5.15 acre site. The letter from the applicant indicates a 5.14 acre site. You're nodding your head, so you're aware of that?
Yes. Okay. Yes. We went back and double checked it. It is the 4.896 acres.
Okay, thank you. The realignment of the sidewalk, is that this short length of what I look at is approximately 50 feet, this meandering sidewalk, or is it the entire length of the frontage on Bristol?
It would just be for the length of the development site.
Well, which is, I mean, that's the entire length along
Yes.
Bristol?
Yes, for this property.
Okay.
Not going past where the drive-through restaurants are.
Understand. So from the sort of the site plan that you showed, it appeared that there were a lot of trees that were on that site. So I'm not sure I totally understand why it was that 15 trees were not donated, but were given to the Public Services Department, presumably for use somewhere else in the city?
Yes, that's correct. Not for this site, for use elsewhere.
Okay. So I'm going to ask about the variance, but before I do that, can you explain, so this is a C2 zoning. Conditional use permit is required for an auto dealership on that.
Yes.
Would it also, a CUP be required if the land was zoned C1?
Yes.
Okay, and so tell me why that use is required to have a CUP as opposed to by right?
It's just the way that was established in our land use matrix. A lot of the properties along Harbor Boulevard, for example, are C2 zoning, and those dealerships, most of them have conditional use permits.
Is there a zoning under which a CUP would not be required for an auto dealership?
No.
Oh, well, okay. So on the variance, and I'll take the height variance first. The criteria you lay out makes perfect sense to me. The special circumstance applicable to the property, and I think the easement of the water district line certainly explains that. The second criteria is the one that I kind of want to poke at a little bit because it talks about whether you'd be granting a special privilege inconsistent with other properties. And I bring it up this way. If the applicant was asking for a variance for their development simply because Ganal Lumber got one, or a property across the street got one, or a property down the street got one, to me that would not necessarily meet the criteria of the first bullet, which talks about special circumstances specific to the property. But if all their neighbors got variances, then it would seem that the second bullet might come into play. So let me do it this way and not talk about Ganal Lumber. So if because of this water district easement, the variance for height is granted because they simply couldn't site the building in such a way to get the square footage that they would be entitled to build, then does that potentially create a special privilege that property across the street down the road might ask for and say, well, we're disadvantaged because we don't have that same variance? Would that be a justifiable rationale to grant the next guy a variance for height?
I'll start and I'll see if Mel can add to my response. It would not be a justification simply to say that another variance was granted for the same thing somewhere. I think in this case, the justification is that the streetscape now reflects a 10-foot landscape setback, for example, and therefore, for consistency purposes, we think that there's justification for a variance in this case. Merely the existence of another variance somewhere in the city is not justification.
Okay, that answers my question. Thank you. So if there was not a variance granted for height, I'm back on height, the maximum height of the building would be 30 feet.
Yes.
I would assume the maximum height of any signage would be 30 feet. You couldn't hardly mount a sign unless you sat it on top of the roof.
You're talking wall signs, not freestanding signs?
Correct.
Yes, that's correct.
So do we have something, I don't have the diagram in front of me, do we have something that prescribes as a condition that no building signage be higher than 30 feet?
Going back to the elevation exhibit.
Yep.
You will see that in this instance, the Audi logo appears to be at or higher than the 30-foot limit. So the answer to that question is no, there is no restriction on the sign height limit.
Was that considered?
No, it was not.
Okay. Okay, thank you, Mr. Chairman.
Thank you. Commissioners, any questions? Commissioner Navarro-Woods.
Okay, thanks for your presentation, Mr. Lee. So I was trying to figure out where the Delhi Channel runs in proximity to this location. I was looking on a map and on a satellite image, and it seems, does it go underground between Gunal? So it's completely covered. It's a channel, a covered channel, and there's no interaction between the properties and Delhi Channel.
Yes, it's an underground channel or covered channel.
Covered channel at that point. Okay. All right. Well, that negates some of my other questions. I did, let's see, in the, in the initial study and mitigated neg deck on 4-18, it says that there was Peruvian pepper trees on site. And then in the following page, it says that that they wouldn't remove any trees along the edges, northern, eastern, and western edge of the project site. Will Peruvian pepper tree remain on site, or is that going to be removed?
I will have to defer to the applicants on that one.
Okay. Have you guys, is a test drive circulation plan in place for this? Or, I mean, I saw the condition that that required that no test drives be done on neighborhood streets, but is there an actual plan on what that pattern might look like?
No, there was not an exhibit that was submitted as part of this application.
Okay.
We did require one for the Cadillac dealership on Harbor because it literally is right next to residences. So we did go into a little more detail with that one as far as where cars could and could not circulate.
Okay. Do you know how many of the parking spaces will be designated for employee use only?
Actually, yeah, unfortunately, the numbers are combined between the employee spaces and the inventory spaces. I did take this off of their construction drawings, but I don't have the actual numbers. I just have the total combined. But once again, I'm sure the architect will be able to address that.
Okay. And then there's a condition of approval that refers to lighting, and it says that the intensity of parking deck lighting shall be reduced from 9 p.m. till dawn. Do you guys actually specify what that, or articulate what that reduction should be? I mean, because technically, if I look at this, I can reduce my lighting by 1%, and I'm in compliance with the condition. But that won't necessarily make the residents across the street very happy.
Yes, that's why we don't specify a specific level or foot candle level, because they could lower it. We could say lower it by 2 foot candles. They do it, and then the neighbors would still think it's too bright. So we deliberately leave it open-ended so that we have that flexibility to say it's still not low enough. It needs to be lowered even more.
I see. Okay. I think that's all the questions that I have for now.
Okay, any other questions? Okay, Mr. Lee, so I have a couple of initial questions, and then I'll have several questions of the applicant. Just first of all, as kind of a follow-up housekeeping item that Commissioner Zick touched on. So I have in the staff report 50,971 square feet. And then there's a reference in the Associated Transportation Engineers letter of May 24th, where all the trip generation comparisons are based on square footages of 75,519. And then I also saw a reference, and I can't remember where off the top of my head right now, I think 58,000 some odd square feet. So I just want to clarify for my initial curiosity now that it is indeed 50,971.
Yes, that's correct.
Okay. Second question, what happened on Bristol? Did the old Ganal site get switched from C1 to C2, or was it vice versa on the adjacent properties?
I was doing some research on this afternoon because it is a little odd that this is kind of an island of C2 in the middle of C1. I wasn't able to find the zone change for this parcel, but my theory is that back before this was Ganal lumber, it was bar lumber, and because it was considered more of a heavy type of commercial use is probably why it was zone C2 at that time.
Okay, I'll take your word for that. Staff report, or there's a conclusion that the proposed project would not exceed ADT of the former Ganal use. Is there historical data that's supporting that gives us, in other words, historical data with respect to the kind of ADT Ganal generated that would allow us to make that conclusion?
I believe the traffic study, I believe our consultant actually went back and looked at the traffic study that was done for Ganal lumber, and also compared it to the trips for the new Audi dealership. But I'll have to defer to our consultants on that.
And he'd be able to tell me when those traffic studies for Ganal were done, hopefully?
Yes.
Okay. Staff report mentions drive access controlled by, let me get it here. Vehicle access to the project site is provided by 2 stop sign controlled driveways along Bristol. Help me understand the configuration. Are these stop signs that a driver would encounter leaving the site? They're on the site. So this isn't an actual intersection at Bristol that's stop signs. Okay, just wanted to make sure of that. Excellent. Do we have in the plans, and I couldn't find it, is there a height that's designated for the light standards on the second story vehicle storage?
Yes, I was checking that this afternoon off of the construction drawings, and I believe it's 28 feet. But I'll have to have the architect confirm that.
So the light standards are 28 feet from the parking surface?
Yes.
Measured from the parking surface?
I believe so. Our architect can confirm that, but I believe the plan shows 28 feet.
And would those be within the 44-foot height limit that they're asking you a variance for? So in other words, would those extend beyond the 44 feet?
No, it would not.
Appendix A from the ISMND identifies approximately 1,034 truck trips. I'm assuming to and from the site. Identifies 1,759 cubic yards of material will be hauled off the site, and another 8,233 tons of building debris will be hauled off the site. First question, from a grading perspective, is that 1,715 yards a net export, so the site doesn't exactly balance? They have to take almost 1,800 yards of dirt off the site?
That I'll have to defer to the applicant on.
Okay. The 8,233 tons of building debris is hauled off the site. One, do we know where that stuff goes? And two, and I know it's in the conditions of approval, the truck route that material is going to travel. That plan has to be submitted to the city prior to the issuing of a grading permit?
That's correct.
Okay.
It's basically a construction management plan.
Sure.
And I believe as part of the haul route permit that Public Services Department issues, it indicates basically where the ultimate destination of any debris will be sent.
Okay, so then on the traffic analysis conducted by KOA, so the traffic analysis consultant contemplated 3 trip generation sources. One was the ATE study, which ultimately was used to calculate traffic on this project. And that ATE field study was done on the Fletcher Jones Auto Dealership in Ontario and another one in Temecula. And then we have the ITE rate, and then we have City of Costa Mesa standards. So based on the studies of the Ontario and Temecula facilities, at least at the time ATE identified a trip rate of 20.08 trips per 1,000 square feet, resulting in daily trips of 1,516. And that was the standard used to calculate trips for this project, 20.08 trips per 1,000 square feet. The ITE rate is 27.84 trips per 1,000 square feet. And City of Costa Mesa's standard is 50 trips per 1,000 square feet. So my question is, why? So the difference between the ATE field study of 1,516 gross trips and the City of Costa Mesa standard, which is 3,776 trips, is more than double. So I'm a little bit concerned and wondering why we accepted that auto dealerships some 80, 90 miles away in areas that are not nearly as concentrated as ours. And I might suggest or assume that there probably are more Audi automobiles per square mile in Newport Beach and Costa Mesa than there are in Ontario and Temecula. Why we accepted that low threshold, that 20.08.
Yes, Mr. Chair, KOA, which conducted the traffic analysis, was a sub-consultant for E-Corp, which prepared the initial study, mitigated neg deck, and Tom Holm is here to address those questions.
Okay. Yes, sir.
Yes, Tom Holm with E-Corp Consulting. With regard to the traffic study, the process that we went through and through the city review was the ATE study compared similar Audi projects, as you mentioned, Mr. Chairman, in the two other jurisdictions. They were estimated to be of similar size dealership. The market areas for those presumably were larger, but the trip generation was considered to be similar. The ITE rate was looked at, and it was considered that the ATE rates were appropriate for the project. There would be no discounting for the prior Ganal lumber use or credit given there. So in that respect, the city considered it to be conservative. The trips, the result was the trips generated for the ICU analysis less than 50 additional trips during the peak hour at all of the study intersections identified by the city. So both the traffic consultant and through the city review process, it was considered that the rates were appropriate, particularly given the fact that no trip credit was identified for the Ganal facility that was located on the site just prior to the current proposal.
Okay, so I'm going to ask you a hypothetical. Had the ITE rate been used, or the actual City of Costa Mesa rate been used, would the proportional difference between the ATE daily trips aggregate versus ITE in Costa Mesa, would that percentage difference, the delta between those, translated over percentage to percentage for the AM peak and PM peak?
Yeah, I don't have the numbers for that. And first off, I'm not the author of the traffic study, but the ITE rate, in looking at the trip generation data and the intersection capacity utilization, probably would not have or did not have a significant change that would have tripped the intersection trip, peak hour trip threshold. As far as the city's own factors or rates that they have calculated, I don't know. I don't have the data on that, whether that would have tripped the threshold.
Okay, and I'm not necessarily right now questioning whether or not if a higher trip rate was used, that it would trigger some kind of mitigation relative to lane capacity. So I'm not suggesting that. The reason more or less why I'm asking the question is I'm trying to be a little bit sensitive to see if we used a different trip rate, that we would actually create sufficient volume, peak volume, to have Irvine and Bristol and Campus studied.
Yeah, I don't have the numbers on that at hand. I think we were significantly below the threshold and below the trip generation from the prior use, which at the time, back in 2017, was the baseline for that area. So I think those are two important considerations.
Okay, thank you, sir. I'm done with my questions relative right now to traffic.
Yeah, and again, the traffic study was reviewed through the city transportation department.
Yes, thank you, thank you. So, Mr. Lee, in reviewing the comment letters on the ISMND, OCTA's letter regarding the city, OCTA understands that the City of Costa Mesa active transportation plan includes a future Class 4 cycle track bikeway along Bristol adjacent to the project site. Please clarify if the project property line has been adjusted to account for future potential bikeway improvements along Bristol. And our response was the City of Costa Mesa active transportation plan identifies a proposed future Class 4 cycle track bikeway along Bristol Street between Newport Boulevard and Santa Ana Avenue. Class 4 bikeways are separated or protected bikeways located within the road right-of-way. There are no plans to adjust the proposed property line to implement this. So I just want to be clear, a property line adjustment is not necessary to create that project. Okay, thank you. So with respect to the analysis of air quality and greenhouse gases, South Coast Air Quality Management District writes that the lead agency quantified the proposed project's construction emissions based on the modeling assumptions that Tier 3, Tier 4 interim, and Tier 4 final construction equipment will be used. However, the lead agency did not require the proposed project to use Tier 3, Tier 4 interim, or Tier 4 final construction equipment in the mitigation monitoring report, nor in the M&D. So my question is, was the analysis for air quality based on the use of Tier 3, Tier 4 interim, and Tier 4 final construction equipment usage?
Yes, and that data was supplied, detailed data on construction equipment was supplied by the applicant's engineer.
Okay, and so then I think our response is roughly because that equipment was used as the basis for calculating emissions, that ergo, of course, that equipment will be used, and so therefore it doesn't need to be identified in the mitigation monitoring report or the M&D?
Not exactly. The equipment profile that was used results in a emissions level for construction that's well below the thresholds. And Tier 3 and Tier 4 equipment can be used in the construction process. So there was no requirement or need for condition or mitigation to require Tier 4 construction equipment.
So are you suggesting that the thresholds, you would have stayed well under thresholds without using Tier 3 and Tier 4?
No. No, the combination of equipment that was used enabled the project to stay well below the thresholds.
Okay. With respect to the number of hauling trips, the 1,034 hauling trips anticipated to occur, either removing from the site the whatever cubic yard, 1759 of cubic yards and 8,233 tons of debris. Do we have any estimate on the span of time that those trips are going to occur over? Is it 1 month, 2 months, 5 months, what? Do you know?
There is. The applicant's civil engineer provided a detailed construction timeline with the phases that were involved. And I would defer to them to.
Yeah, maybe they can answer because I haven't seen that. So
yeah, they can highlight that, but it would certainly be during the demolition and site preparation phase where it would be peaking. And that was taken into account in the emissions analysis.
Did the traffic study count test drives?
No.
Did it count the use of using courtesy vehicles shuttling customers back and forth to their offices while their car is being serviced?
Well, let me qualify that by saying it was based on the trip rates from the similar facilities, and those trip rates would likely have included customer trips to the site and other trips.
Okay, and I respect your
But this-
expertise. I would prefer an answer better than likely, and I know what you're saying. You don't know, so
I don't have an answer.
That's fine. That's
It's
fine.
based on ITE rates and the ATE comparable facility.
Okay, okay,
So
fair enough.
I don't have an answer for
Okay,
that.
I appreciate that. I appreciate that. Long night, Ms. Parker? No, long night, Iggy? Okay. Okay, I think that's it for my questions for now. Any other questions? Thank you, sir. The applicant, please come forward.
Well, good evening, commissioners, or Mr. Chairman, and members of the commission. It's been entertaining. I enjoy it very much. I'd like to start off and say I'm Don Lamb. I represent Fletcher Jones Motor Cars, Fletcher Jones Management Group, and very pleased to be here tonight to give you all positive information and news for the city. Something that most cities out there are dying to have, and you won. You attracted Audi from the city of Newport Beach without them knowing it. You brought them to this city, and the city will be rewarded with a dealership that in 2021 is projected to have a gross sales of $160 million a year. Starting year one, that's $1.6 million to your city budget every year from here on. And we felt that was an excellent opportunity for the city, and we're proud of it as the applicant, and we'd like to thank the staff on that behalf. To make this happen, this started off as an interim move, and in the staff report, it talks about that a little bit, so I'll focus more on that than the graphics that Mr. Lee has already shown you. This dealership is a franchise. It was owned by Auto Nation, which was part of its franchise location down on Pacific Coast Highway. The corporate Audi decided that that franchise needed to be sold, so Fletcher Jones Motor Cars, the operators of the Mercedes-Benz dealership in Newport Beach, was able to purchase that. And through negotiations with the other affected Audi dealership in the Santa Ana Auto Center, owned by Roger Penske Motors, through all the haggling, this particular site was finally accepted within range of both dealerships through significant negotiations. But the deal that was struck said they only had 90 days in which to move it off Pacific Coast Highway and open it in Costa Mesa. So your staff, due to all the hard work last year, Mr. Mel Lee, Jennifer Lee, Bart Mejia, Barry Curtis, and all the staff behind the scene, they were able to get the interim location open down at 375 Bristol within 90 days. So that was a lease of the Autoplex Center, where you know the Audi dealership is now. They went from a complete auto center to a dealership. They moved all the inventory, all the personnel, all the equipment in over the weekend, and they got it open on April 1st. So that was extremely stressful, and they did it thanks to all of your staff. The permanent location, this Ganal lumber site, is a long-term ground lease. The owner would not sell, but it worked out perfectly for Fletcher Jones and all others involved. So this site has been through 3 different variations of design, sent to Germany. The German architects kicked it back and forth. So what you see in front of you is finally the collaboration and final approval by corporate Audi, based on its graphics, its style, its modern architecture. the size and shape. It started off as a much larger building, as Mr. Lee and Ms. Lee, everybody knows. It has been scaled down in size to be certain that there's plenty of inventory on the site. This slide, at least it doesn't duplicate Mr. Lee's. He did such an excellent presentation, I ran out of things to talk about tonight, so I'm going to go a lot faster. The interim you can see down at the Autoplex, the new dealership site, is the former Ganal Lumber. This particular slide doesn't really reflect the Metropolitan Water District water line, but on the ones Mr. Lee showed, you could see it bisecting the property. It is a 15-foot wide easement that cannot be moved. You cannot relocate this water line. It is a 36-inch high-pressure steel line. It runs from the Yorba Linda Deemer filtration plant. It comes down through Orange, Santa Ana. It is the main water supply to South Coast Plaza. It passes by here and goes down and serves most of Newport Beach. So it is sacred to MWD, and boy, they don't want anybody near that thing. So this building is very severely restrained or constrained to get the length that was needed for the service garage not to trespass into that easement area. This overhead slide, well, I'll just really move on. You've seen most of these through Mr. Lee's presentation. The architecture, again, from Bristol Street, went back and forth over the architecture, felt this was a very nice design. Again, looking from the southerly driveway north, and if you're curious, yes, Audi is having a sale right now on white cars. They are overstocked. Too many here again, same architecture. The freeway side. This is not highly visible from the freeway. Actually, there's a grade differential, so you can just barely see up to the building on the property on this backside. Floor plans, yes, the service center is on the ground floor. Sales is on the second floor. It's a very modern type of design like the Mercedes-Benz over in Newport, where the garage is airtight and closed. And that's really it as far as the site plans. The variances we feel are very much justified concerning the height because of the constraint of this building, dropping it down. This building only covers an FAR 0.24. Your zone allows up to 3.0. So it's even less than the floor area ratio. The front setback, the landscape that we looked at, maybe to answer that question of why this property is the only one in this block zone C2. All the others are zone C1. It probably goes back in the days when people really didn't care about spot zoning or determined that that was illegal. So this property was zone C2, which is very odd. It probably should be a C1, and if it was, it would have conforming setback standards for the landscaping. And moving from there, we feel that it's just an excellent project for the city. It implements your general plan, your zoning. We feel that the height variance is justified, the setback for the landscape's justified. I would like to say the comments that you have about the impacts in the MND, traffic, air quality, and the like. Picture this for a second. All of those studies were done as if this is vacant land. The words were in there saying that it's vacant property. It is not vacant property. It is the former Ganal Lumber retail building. If not this dealership, tomorrow a retail store could come in and get a business license and open. So if you think about that, that traffic impact should be the given point of measurement. And then from there, the incremental increase only over that amount caused by this dealership would be truly what you're looking at. But CEQA looks at existing situations, so I just wanted you to know that really this is not a significant impact. And in fact, a retail store on this site would have a higher amount of traffic as a permitted use than this dealership with a conditional use. So it's just something to keep in the back of your mind. The traffic study can't say that. The traffic study complies with CEQA's requirement of existing situation. And in existing, it is a vacant building. But common sense tells you that there's no credit being given for the old Ganal lumber traffic. But if you gave these people that credit, you have the same, if not less, and a different type of pattern, and you don't have the wood trucks coming in and dropping off lumber and exiting every day and the like. So we feel, again, it's a much better situation. And I can answer some of the questions if you have further on the traffic study. But overall, we just simply are asking for your support. This is a very large sales tax producer. It will probably be your most successful and highest performing car dealership in the city by the second year that it's opened. Fletcher Jones is very good at managing car dealerships. They own 14. They're not the largest in the country. AutoNation owns 240. But Fletcher Jones has the ability to make these highly productive, very professional. The Mercedes store in Newport Beach produces over $720 million a year in gross sales. It is almost half the volume of all of Fashion Island Shopping Center. This dealership, it will be the second Audi dealership owned by Fletcher Jones. They bought one up in Beverly Hills, they turned it around, and it is now the most successful Audi dealership in the United States. Fletcher Jones plans on this being their number 2, and hopefully they said within 5 years they would like to make this their number 1 in sales in the United States. So we've all been very excited about it, and we'd like to share those positive comments and not necessarily everything focused on cars and driving. So that's the positive aspect. I'm sure you're excited about it, the staff, everyone else is. Again, to capture this was truly very impressive that Costa Mesa did it. They tried hard. This is an economic development effort, and they got it, and you won. So thank you very much. I'd be happy to answer your questions.
Thank you, Mr. Lamb. Commissioners, any questions of Mr. Lamb? Commissioner Zick.
Thank you. I feel bad on the heels of all that excitement to have such a dry question for you.
No, that's fine.
I'm following up on the chair's question regarding the height of light standards on the
yes,
the parking deck. So I'm not fully understanding the architecture. So you indicate you have 2 stories with a rooftop parking deck. So I see cars parked on what I would call the second floor, and then there's a roof on top with additional cars parked that I cannot see in this diagram.
Well, if you look at this rendering, the showroom is above the portico, the drive area, and the top of that roof has a parapet wall. It's your 3 or 4 feet high. That is the highest point on the property. That is at 40. I'm sorry. 40. Where's my number again here? 39 feet. That's 39 feet to the top of the parapet. There is mechanical air conditioning equipment in the middle of that roof, and that package of air conditioning equipment that you probably can't see from the street, it's at 44 feet. So that was that 5-foot additional.
Where's this rooftop parking deck?
In this same slide, if you see the palm trees to the back, the rooftop parking deck is on top of the first floor back there.
And what is that elevation above finished grade?
That, I don't have the numbers, but you can see it's considerably lower than the front building. The numbers that I had, and I wrote down here, that deck should be at 18. Let's see.
I think the plan is showing 23. If you look at handwritten page 32.
So the deck surface is at 23? So the parking deck surface is at 18. The parapet wall is at 23. And there will be light standards on that, which are...
That's what I was wondering about. So if the deck is at 18 and the light standards are 28 feet tall,
they're not. Well, that's what... Excuse me 1 second.
Thank you.
It comes in just about the same height as the front building, but I'm going to introduce Mr. James Spence, our architect from Gensler Architects in Dallas. Thanks.
Good evening, everyone. I'm James Spence. As Don said, I'm with Gensler Architecture, here to answer any questions you may have. But in terms of the lighting regulations, so the second floor, the deck is at 18 feet, and we will be able to manage with 10-foot light posts that will be mounted onto that 18-foot deck that will serve as the parking deck for that floor.
The top of the light standard being at 28 feet then?
Yes, sir.
Okay. Thank you, Mr. Chairman.
Thank you. Anyone else? You might have your Gensler representative stay close. So on handwritten page 38, which is, actually, there's probably a better, handwritten page 39 and handwritten page 40, which are the site and paving plan, west and east. And I'm noticing on site plan keynotes number 16, it says future building expansion. What is that? And what are the dimensions of that? Is it 1 or 2 stories? How many square feet additional is that?
So that is very much in the preliminary plans for Fletcher Jones. It's just an option for now. What he's wanting to do is have the option to expand and add more service bays. We have yet to execute any kind of exercise there as far as seeing how much extra square footage, but that is very much just an idea for the future as of this moment.
So, Mr. Lee or Mr. Curtis, let's suppose they want to add that expansion at some point. If that additional square footage did not stay within the 0.3 FAR, what would happen?
So whatever additional square footage may be planned for at this point by the applicant, it's not included in the evaluation that's before you this evening.
No,
So
I understand that.
Anything that came before following the decision on tonight's item, it would be evaluated by staff.
I understand that. What I'm trying to avoid is piecemealing and incrementalism. And if there are future plans to add, what might that do to traffic and potentially to the FAR? So I get, I'm not supposed to look at that tonight, but I've also been on that side of the dais and I know how to step projects forward. So I just want to try to have an understanding of what exactly they're envisioning for that some point in the future.
If the applicant would like to speak to any potential ideas that they have for the site, that's fine. From staff's perspective, that's not part of the project and it's not
Totally
evaluated.
I'm just asking, if something came forward later on and they wanted to exceed the 0.3 FAR, what would they have to do given the fact that this was approved tonight? That's all I'm asking. 16.
Yes, Mr. Chair?
Yes, sir.
Just to clarify, the 0.3 FAR is established in the city's general plan. Yes, there is a procedure to exceed it, but it would require basically an amendment to the city's general plan. So I guess the
potentially
short
measure
answer
Y
is,
vote?
right, so the short answer is they would not at any point be permitted to exceed the maximum allowable FAR.
Good, that's what I wanted to hear. All right, thank you. Any other questions? Yeah, Commissioner Navarro-Woods.
I just had a few. I noticed that there's only 3 ADA sites in the parking area, and I guess this might be a question for staff. Is that all that's required by building codes?
So the site's been updated and we have added extra ADA parking spaces. So we now have a total of 7.
Okay, and then where are the other 4? Are they close to the vehicle service area?
Yes, so if you look to the plan northwest of the display parking, immediately adjacent to the building where those white cars are on the site plan. Sorry.
I don't know if we're looking at the same thing. Are we? Okay.
So yeah, where Mel's pointing.
Oh, white cars. Okay,
right,
I see
so
them.
where Mel's pointing right now,
Yes, yes.
those immediate parking spaces will all be, the closest ones will be ADA.
Okay. Will you have electrical vehicle charging stations? I know that Audi has some hybrids.
We will. Yes,
Okay.
ma'am.
Has the area, because of its proximity to the Delhi Channel, even though it's covered up, it is, it's a pretty important little channel because it drains directly into a marine protected area. And so has the area been, have the bioswale retention sites been sort of, because it hasn't been graded yet, right? And so I want to make sure that these bioswales are truly going to capture the runoff as intended, and that the area will be graded accordingly so that there isn't surface runoff that will eventually go into the Delhi Channel and then again into a marine protected area. I don't know what that question was, but I'm curious, just because I don't have a whole lot of experience with grading such a large site and then making sure that they're draining directly into the bioswales. But is that something that's usually done by a civil engineer just to ensure that runoff is captured?
That is correct, and we have our civil engineer here tonight if you need any further questions answered, but we do have bioretention basins placed along the site at multiple locations. They have completed the WQMB, I believe.
Okay.
So we meet the requirements there.
Okay, and then, let's see, I had a question about the Peruvian pepper trees. I call them Brazilian peppers. Will those remain on site, or are those going to be removed? Removed. I'm happy to hear that because they are a highly invasive species, and we have like a $3 million project just to remove that in Newport Bay. What about lighting? You do have residents that live right across the street, and even though there's a condition of approval, a condition that requires you to reduce the lighting, it doesn't say how much you would reduce it by. So what would be your typical practice?
So we are required to lower our site lighting down to 0.5-foot candles along property lines. And we are aware of the residencies across the street. We are working with our MAP engineers to apply to both Title 24 and city regulations as far as uplighting and lighting along our perimeters.
Okay. And then my biggest thing is really employee parking. And this is mostly, and I will fully acknowledge that I have a bias because employee parking at Fletcher Jones and Newport Beach often interferes with our own staff operations because they essentially take over Bayview Place. I don't want to see the same thing happen in Costa Mesa. So how many employee sites are designated? What's a typical number of employees that you would have on site on a typical day, and then how many sites are provided?
So it's tough to say from a general, that's more of a management on the Fletcher Jones side, but what the document that Mr. Lee provided in his staff report, he highlighted a blue area. That is a total of 94 spaces that we have designated for our employees for Fletcher Jones, which is extremely generous. They will not be hitting that 94 mark, I can guarantee you right now. But we have, I guess you could say, overcompensated for employee parking just so that does not happen and they do not take customer parking or the display spaces up front as well.
Okay, and then do you guys have a test drive circulation plan or sort of a rough idea of which way they would go?
I cannot answer to that question, I'm sorry.
Okay. Okay, that's all for now. Thanks.
Anyone else? Okay, so Mr. Lamb, this guy covers me because sometimes I forget to do things I'm supposed to do, but I'm sure you've read the conditions of approval, and do you agree with them?
Yes, we agree with the conditions and the mitigation measures.
Thank you, sir, very much.
Sure, thank you.
Okay, I will open the public comment portion of the public hearing. Anyone wishing to speak to this item, please come forward. Yes.
Well, I think it's great that you're moving to Costa Mesa because, of course, we love to get the revenue. But I'm sorry to bring this back to the sober living situation. And because it's an election year coming up, I'd like to talk about the octopus of corruption involving sober living in our city, which also involves car dealerships, Hotel California, Morningside, et cetera. Those Mercedes vans that you see driving around, they're like $60,000 plus. I'm not sure how much it is. And then I have frequently seen Fletcher Jones on the back of those Mercedes vans. I'm just saying. And then there's Theodore Robbins Ford on Harbor, and they're the white vans. And so I'm just saying, then you look at people's campaign contributions, i.e. your friend Jim Rickheimer, Mr. Eric Call, and Steve Mensinger, and look at their campaign contributions from Fletcher Jones and Theodore Robbins. I mean, I think it was $5,000. I can't remember. I don't have it in front of me. But when you go to vote and when you start thinking about the next year and everything that goes on around here, look at the campaign contributions and look at who has made money off of sober living. Car dealerships, therapists, gyms, massage parlors, pawn shops, they've all made money off of this. And I'm sorry, but every time Mr. Lamb comes to the podium, and he's a really nice person, but he always asks for all these variances, and he always smooths talks. And I can't remember which one of you asked the question about whatever you just asked, and he tells the architect, oh, don't worry about it. I mean, it just annoys me, and I would just like you to pay attention to that.
Thank you. Yes.
Well, let me start by saying that I'm looking at BMW, so I'm really glad you guys are coming. I'm looking at an RS 7. Test drove them and love them. Very nice cars. But on the same agenda, I think the white elephant in the room is, and I might be slightly mistaken, but I don't think so, but isn't that site a historic building? Because let's go back to Ganol. Ganol wanted to renovate, and I know because I was on some of the early negotiation, because I was hoping to do some of the work with them, and they weren't allowed to. So they looked at the property to the left, which is actually a county property and not a city property. And they negotiated that, and then negotiated with Caltrans to get that approved. So why don't we look at the whole thing? Don't horse trade this thing. I mean, granted, we need the revenue. Granted, we got them, Fletcher Jones, to come into town. It's the biggest parcel of land left around here, guys. Wake up. There's nothing else. Try Irvine. That's about it. So the way this thing is working, you guys aren't being truthful. And that's not doing the right thing. Be truthful. Be honest about it. Don Lamb is a consultant now, and he looks a hell of a lot better than he did when he sat down here as a director of services for the city of Costa Mesa. Please. Why don't we tell everybody what's going on around here? This isn't a horse and buggy show here. Fletcher Jones is in here to make money, and I have nothing against Fletcher Jones. Don't get me wrong. I'm all for it. The problem I'm having is with the rest of the circus that's going on around here. You guys are asking questions, and you're leading towards something. What am I getting out of it? How am I benefiting? What am I going to get from my contribution? This is what it sounds like. I cannot believe that there's not enough people in here to figure this stuff out. Because unless you're here day in and day out, you don't get to see it, guys. And I mean, it's a beautiful building, but I do have a question to the architect. How come you didn't put a window on the backside so people can see the cars from the freeway? Like the Porsche dealership in Irvine.
Well, I'd ask you to address the commission. He can answer it if he wants to when he comes
Well,
back up.
I'd like, okay, I'll address it to you, and perhaps you can ask it so he may address it, because I think that would be an added bonus, personally, to the dealership if those vehicles could be seen from the freeway.
Perfect.
But on the same point, let's look at this, because Ganol Lumber was not able to renovate that building because of its historic value. And now you're concerned with where the trash is going to go. It's going to go to the landfill in Irvine. And the concrete and asphalt, that's going to go to construction circles to use material. So don't.
You're welcome. Anyone else? Okay, I will close the public comment portion of the hearing and ask the applicant to come forward again. Yes, sir. I will turn it on. There you go.
There we go. Okay, thank you. So just very quick responses to help clarify the record. The question about campaign donations, that's very clear. Fletcher Jones does not donate to any candidates in Costa Mesa, nor have they ever. And you have limitations of $249 in a campaign year, in which over that you would have to be excused as a council member. So not a problem there, hasn't happened. So that clarifies that. Don's annoying, I'm sorry, so I'll go on from there. I do enjoy this, and I really think that I love to hear everybody in the audience. They're great, and it's always good to hear people come and participate in public hearings. Good for them. Was it a historic building? No, the old Ganal building was not a historic building. The old Ganal building was the subject of landlord-tenant negotiations. It's a ground lease. Ganal Lumber could not come together with the landlord on a new lease. It expired, so that's why they executed the new lease over on the Orange County Flood District land next door. So Fletcher Jones came along and did negotiate a lease with the landlord. So this is a long-term lease, and so the building will be torn down, completely scrape the site, and build all new and fresh. And that's basically it. So, and as far as windows on the back side, that's the service garage on the ground floor. The second floor parking deck will have cars, some of the inventory that would be visible from the freeway, but you really wouldn't see windows into the showroom because that is the service garage on that back side. And that's it. Happy to answer any other questions if you have them.
Okay, thank you, Mr. Lamb.
Okay,
Commissioners,
thank you.
any further questions? Commissioner Navarro-Woods.
Oh, yes, good.
You know, that's funny because I kind of noticed that too. Is there any signage on the back of the building that would be visible from the 73 identifying it as an Audi dealership?
There is the intent. I'm not sure if it appeared in the slide, but like on the front, corporate Audi has exactly the color, the font style, the trademark rings. So I believe that they're going to be on all the sides that the sign ordinance allows it. I know we have it on the front corners, north and southbound in front, but let's see, I don't know if you have the back slide. But if the sign code allows it, yes, it would have the same graphic, the same Audi and the rings that are on the front, and that's it.
I have a question. How many electrical vehicles does Audi intend to put out in its fleet? Like, if you were to express it as a percentage, 5-10 years from now, what do you think the percentage of hybrid vehicles being sold would be?
I wish I could tell you, and I wish I knew where the stock market was going to, and I don't know. I really don't.
Okay.
And Fletcher Jones is new at Audi. They only have the one dealership, but they're trying to build it, and I really don't know what corporate's doing on it. Wish I could answer. But.
Okay, anyone else? Okay, so quick question.
Yes, sir.
Well, I'll have you stay there, but this is for Mr. Lee. So the technical analysis on air quality and greenhouse gases was based on, in part, a roster of construction equipment provided by the applicant to the technical analyst. Am I correct on that?
Yes, that's what Tom
Okay.
indicated, during his
So-
presentation.
So I've got this, and here's why I don't want you to go away, Don.
Yes, sir.
Actually, it's in page 3 of 32 of the, I think it's the CaliMod charts. It shows a T4 final, T3, T4 final, T4 interim, T4. It's about 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 pieces of equipment that are tier 3 or tier 4. I'm going to ask you, since you provided these and they were used as a basis for your analysis, or your technical consultant's analysis, if you'll agree to require the use of that equipment in the conditions of approval. I know you'll probably already use it, but I want to make sure it's in there.
I would like to say yes, but I have to say no. And may I explain why? I've been through this in many cities and processing of mitigated negative declarations and EIRs, and it's such a level of preciseness if it's locked in as a condition that it's hard for the contractor at this point to exactly dictate all the equipment, be it a Caterpillar or this model, this model, this model. So most of these are industry standards that are used, and it's the range of equipment. Is it possible here or on all the other construction sites I've worked on that a piece of equipment could be larger than, have different emissions characteristics? It could be less. So I would have to say that these are industry standards that are used, and to lock the contractor into that specific fleet of equipment would also then require the city to be an enforcement entity and track it all. And the city's not in the business of enforcing air quality. Air Quality Management District does that. So if you really, really feel heartburn over it, I'll say, okay, let's do it.
How about if we just, that
you can put it in.
Tier 3 and Tier 4 is used, not a specific number.
Okay, that's fine,
All right,
sure. That helps a lot from a practical standpoint.
Okay,
Great,
and then my
thanks.
other question would be, would you be amenable to a modification or addition to condition of approval number 6, test driving of vehicles shall not occur on residential streets or within residential neighborhoods. Applicant shall submit to the city a test drive circulation plan.
Sure, certainly, that's fine.
Thank you. All right. Thank you very much, sir. Anyone else for Mr. Lamb? Thank you for your
Great.
time. I will close the public hearing
Thank all of you.
and then ask if the commissioners have any additional questions or comments or motions. So I move that the commission adopt resolution, adopt the initial study mitigated negative declaration for the project, including the mitigation monitoring and reporting program, and approve planning application 19-10 subject to conditions of approval and mitigation measures, including CUL1 archaeological monitoring and accidental recovery, provided in the supplemental memo dated August 12th. Also to include provision of conditional of approval that Tier 3 and Tier 4 equipment be used, not exclusively, but also be used in the construction process, and that the applicant submit a test drive circulation plan to the city. Is there a second? And I'm on the wrong panel. So I'm, okay, and Commissioner Russell seconded. Any comments on the motion?
Mr. Chairman.
Commissioner Zick.
Are you including the 2 variances, or is that going to be separately handled?
Did I miss something?
Well, I didn't hear you mention specifically approval of the 2 variances.
I think it's in planning application 1910. Am I correct, Mr. Curtis? Do I have to mention the variances?
That's correct. You're correct.
Okay.
Then the question I have is whether we are clear that the 39 feet is the maximum height of the building, with 44 feet being the height of the equipment on the roof.
I am clear on that, yep.
Is that clear? Okay, thank you.
Anyone else? Okay, I will call for the vote.
That motion carried 5-0 with Commissioner Colbert and Commissioner Torje absent.
Okay, great, and that decision is final unless appealed to the Planning Commission, City Council within 7 days. Thank you much. Good luck, gentlemen. Okay, reports, development services, Mr. Oh, I'm sorry. I want out of here, right? All right. Thank you very much. I'll wait for the chamber to clear a little bit, and then we'll go to public hearing 3. Okay, Julie, public hearing item number 3. I tried.
Public hearing item number 3, Code Amendment CO-19-01 to amend the citywide land use matrix to allow emergency shelters to be located in the Industrial Park MP zone and the emergency shelter development standards and the special land use regulations in Title 13 of the Costa Mesa Municipal Code, and approval of an initial study mitigated negative declaration for the proposed emergency shelter at 3175 Airway Avenue.
Thank you. Mr. Curtis.
Good evening, Mr. Chairman, members of the Planning Commission. We have this evening, as you indicated, or as Julie indicated, a code amendment request to amend the citywide land use matrix to allow an emergency shelter to locate in the industrial park zone, subject to approval of a conditional use permit. Also would be adding a footnote 10 to the land use matrix that would indicate that for city-sponsored shelters, the conditional use permit would not be required in both the existing PDI zone where shelters are currently permitted and the MP zone where the code amendment proposes to allow them. And finally, there's a little bit of minor cleanup to the special land use regulations for emergency shelters. I also have with me this evening, who will come up in a moment and talk towards the specifics of the operational characteristics of the proposed shelter. I have Justin Martin, the acting, I guess he's acting city manager today, acting assistant city manager with us this evening. I'll call him up shortly. The code amendment would allow the city to develop a 50-bed permanent bridge shelter shelter facility on a city-owned parcel located at 3175 Airway Avenue. Staff has also prepared an initial study, mitigated negative declaration to evaluate the environmental impacts of the code amendment and the proposed bridge project. So just in a way of background, get the name wrong. Beginning in 2010, the city of Costa Mesa initiated a number of actions to address the needs and impacts of individuals experiencing homelessness in Costa Mesa. At that time, the city established a homeless task force, adopted a 9-point plan to address homelessness, and formed the Neighborhood Improvement Task Force, known today as the Network for Homeless Solutions. Moving forward to January 2018, Costa Mesa was named in the federal lawsuit, Catholic worker suit, along with the County of Orange and the cities of Anaheim and Orange. This related to the county's clearing of the Santa Ana Riverbed encampment. The lawsuit challenged the enforcement of each of the defendants' anti-camping ordinances, and through that process, Costa Mesa was enjoined from enforcing its anti-camping ordinance. Through the settlement of that lawsuit, the judge directed the city to provide a total of 62 shelter beds in the city. 12 of those are being provided at College Hospital through their crisis stabilization unit. It's not open yet, but it's in the process, which left 50 beds to be provided through an emergency shelter. In April 19th, the city opened its temporary bridge shelter at the Lighthouse Church in West Costa Mesa. That facility is managed by the city along with a professional shelter operator, Mercy House. The city, by opening the temporary bridge shelter, the city was allowed to enforce its anti-camping ordinances again. And moving forward with the temporary shelter, in addition to allowing us to enforce those ordinances, it allowed the city time to pursue a longer-term solution. Taking a step back, Senate Bill 2 in 2007 required that cities create a zoning district in which shelters are permitted by right. In response to that law, Costa Mesa designated the PDI, the Planned Development Industrial Zone, as its required by right zone. The PDI zone has properties located in the airport industrial area where the proposed facility is located, as well as in the northwest portion of the city, near and also including portions of the Major X zone. This map indicates those areas in the city where shelters are currently permitted by right as a result of SB2. It's the facilities up near the Measure X zone that are yellow in this graphic, as well as next to the airport, also yellow facilities, yellow parcels on the right side of this graphic. Circled in red is the location of the city's proposed facility, which I'll speak to later. Beginning in October 2018, the city initiated a search for a permanent shelter site. city staff and the city council looked laboriously across the entire city for a potential site. The staff and the council analyzed 52 potential sites, both in the PDI zone and throughout the balance of the city. Unfortunately, at that time, we were unable to find any available sites in the PDI zone. There were a number of sites for sale or lease in that zone, but all of those had were condominium projects with CCNRs that prohibited shelter use on them. That essentially, through that process, the city ultimately broadened its search outside the PDI zone, and in April 2019, the city purchased a property at 3175 Airway Avenue for use as a permanent bridge shelter facility. The purchase was done unanimously by the city council. The site would be managed by the city along with the professional shelter operator Mercy House, is the same as the case with our temporary bridge shelter. And the facility is planned for a 50-bed reservation-based high-security shelter offering beds to those in need. Here's a quick vicinity map. This, what I'm highlighting here, is the 55 freeway on the left side of the graphic. The 405 freeway is located north of the site, at the north top of the map. And you can see John Wayne Airport located just to the east of the site. Here the site is in yellow. The site specifically is located at the southwest corner of Airway and McCormick. Again, what's being proposed is to repurpose roughly 15,000 square feet, or approximately 1/2 of an existing industrial building at the site. It would create the 50-bed facility I discussed a moment ago. In preparing our CEQA analysis for this and working with our consultant, we actually analyzed the potential for up to 100 beds, recognizing that at some point in the future, we may be in a position where the city's place and time counts would potentially require for additional beds. So we did analyze 100, so we would not have to go back through this process if we needed to enlarge facility to a limited extent. The balance of the building would be used for warehouse uses similar and consistent to what has been used in the past and consistent with what's allowed in the MP zone. And now, as I indicated, I'd like to ask Mr. Martin to come up and speak about the programming and operations of the proposed facility.
Thank you, Mr. Curtis. Mr. Martin, welcome.
Good evening, Chair DeArco, members of the commission. I think Mr. Curtis did a really good job at kind of wrapping up the timeline. At the temporary shelter, we're going to transition the operations that are at that facility, and we're going to mirror them at the permanent facility. Daily, the day starts with a 5 a.m. wake-up call and ends with a 10 p.m. Kind of last lights out call. Throughout the day, there are some volunteers on site. There is laundry that's being done. Showers can be taken, restrooms can be utilized. Meals are served in 3 periods of time. 6 a.m. to 9 a.m. is breakfast, 11 till 1 is lunch, and 6 p.m. until 8 p.m. is dinner. Again, while there are 50 people who are staying at the shelter, they're not actively staying there 24 hours a day. The system is reservation-based. It requires transportation to enter and exit the site through a shuttle transportation system or through a ride share such as Lyft or Yellow Cab. Clients leave the day to work on their housing plan. The model of the shelter is a housing first model, which requires them to have a housing plan that's coordinated through their case manager, which is a city employee. If a client is not working towards their housing plan, they do run the risk of being exited from the shelter. A client's plan can start with getting a license at the DMV, to getting a medical appointment, to working with a county telecare worker, et cetera. Each person's plan is different. However, they have to be working towards that plan to remain a client at the shelter. Some services will happen on site. We have a veterans group that's meeting currently. We have some support groups, but it's also important that we are sending them out back into the community so that they can work to become socialized once they're ready to return. Clients are required to meet with their case manager weekly, sometimes more than that, depending on whether they have a voucher that might be expiring or if they're close to being housed. To date, in the first 100 days, the temporary shelter has housed 14 individuals and provided several thousand linkages to services throughout the county and the state. Again, it's a housing first model that also focuses on a good neighbor policy. That policy includes 24-hour security on site. It includes screened perimeter fencing and cameras. It also includes roving patrol within a half-mile radius of the facility that takes place daily. What we've seen in our temporary shelter is actually a cleanup of the neighborhood, which was one of the most heavily impacted neighborhoods in the city related to homelessness, now where it's one of the better parts of the city because of that roving patrol and because of the expectation that this is not what this community is expecting in this neighborhood anymore. So we will be transitioning that type of operation to the permanent shelter as well, should it move forward. Let's see here. Again, there's 24-hour security that's provided through Mercy House, our professional shelter operator. There are opportunities for volunteers throughout the day or throughout the week. Meals are served, obviously, so that is something that volunteers do assist with. And again, we contract with some outside agencies through Mercy House to help provide some of those wraparound services, both in-house and out-house. So I'm happy to answer any additional questions that you might have. It can be specific to operations or otherwise. Thank you.
Okay, Mr. Curtis. Thank you, Mr. Martin.
Thank you, Mr. Chairman. Once I complete the rest of the presentation, Mr. Martin and I will both be available to answer any questions you might have. One of the issues that we looked at with this, one of the issues that we looked at with this site was its proximity to the John Wayne Airport. The site is located in a 65 CNEL noise contour for the airport. Because of its location and proximity to the airport and the fact that this requires a code amendment, it's subject to consideration by the Airport Land Use Commission as far as consistency goes with the airport environment's land use plan for the airport. ALUC, I'll talk about that in a sec. Tenant improvements are as a component of the project, tenant improvements are required to attenuate indoor noise levels to a 45 CNEL noise limit within the shelter. We recently, earlier today, received the initial noise analysis for the site, and it's showing without attenuation noise levels interior at about 45 CNEL, so it's actually already very close. PDI areas, as I indicated before, are areas where shelters are currently allowed by right. There are PDI zoned areas in the airport industrial area which are roughly the same distance from the airport as the project site. So had we been able to find one of those sites available, we wouldn't even be going to the Airport Land Use Commission. We would just be moving forward with the project. And a number of the PDI sites are also within the 65 CNEL noise contour for the airport. Really why we care about that is how those noises impact folks that are clients at the facility. In looking at that, the shelter clients generally will face less noise exposure per day than office industrial employees in surrounding buildings. And they also, that includes part of the day they're there as 8 hours of the commercial jet curfew at the airport. Over the course of a week, because shelter clients may be there for 7 days in a week and most employees work 5, it's roughly equivalent as far as the noise exposure in a week between an employee and someone in the shelter. Long-term exposure, though, is significantly less for clients. The clients in the shelter typically, the typical plan is for them to be in the shelter for no more than 30 to 60 days. Employees obviously could be exposed to these noise levels for years or even decades working in some of these businesses. And really, in looking at this use, the shelter functions very similar to a hotel or extended stay hotel, where folks, as Mr. Martin indicated, spend a good portion of the day away from the shelter site, and they're back in the site in the evenings and overnight. So we believe that that addresses a lot of those issues related to the noise, and couple that with the benefits of the sound attenuation that will be required. As I spoke of earlier, the code amendment is to address the fact that 3175 Airway is located in the MP zone and the shelter use is not allowed in the zone. Therefore, the code amendment is required to allow shelter in the zone. We are not changing the city's SP2 area, the PDI zone, through this because we didn't want to enlarge the area where shelters could be allowed by right. So what we did was we looked at the city's other industrial zone and are proposing to allow it in that area subject to conditional use permit. So kind of going back to the map I showed earlier, the yellow areas are those where shelters are currently permitted by right. The purple areas are where it would be allowed through a conditional use permit, and again, in red shows the project site. If approved, the code amendment would allow emergency shelters in the MP Industrial Park Zone, and it would require a conditional use permit if it wasn't a city-sponsored use. The code amendment also includes minor changes that one would not require CUP, as I said, if it was a city facility. There's some minor revisions to 4 of the existing standards for shelters to really just clarify what the intent was. And then adding 1 new standard, which requires shelter operators to patrol within 1/2 mile of a shelter site. To date, we've received 1 comment related to the project itself, and it's from the property owners of a building located at 3185C Airway Avenue. They indicated their opposition to the code amendment. They discussed issues they're currently having with homelessness in the area, and they believed that a shelter would exacerbate those conditions. Unfortunately, the correspondence we got from the owners didn't have a way to contact them. We've made an attempt to go out to the site, which they own, but they don't run the business there. They're just the landlords, and there was no phone number or email. We would have liked to talk to them and explained kind of what the process is and what all of the operational characteristics that Mr. Martin referred to, and also talk on the fact that what we're experiencing with the temporary bridge shelter is actually a cleanup of the neighborhood around it, not a worsening. For CEQA, an initial study and mitigated negative declaration was prepared by First Carbon Solutions and circulated for a 30-day public comment period, which ended on August 11th. We received comments from 5 agencies related to the MND, included in that number is 2 tribal groups. In looking at those those comments, there really were no substantive issues, and the issues were all addressed in the document. The mitigated negative declaration identified 4 mitigation measures in the areas of biology, cultural resources, geology, and hazardous materials. The mitigation monitoring and reporting plan program was provided to the commission through a supplemental memo. As I indicated earlier, it is actually required for the final action by the city council, but it was provided for the commission for informational purposes. For next steps, because this item is located in proximity to the airport and it requires a code amendment, the Airport Land Use Commission will be considering this item on August 15th. ALUC will be reviewing the project for consistency with the ALUP for John Wayne. Depending on what determination they make, should they find it inconsistent, the city council could override that determination through a supermajority vote. The city council is expected to consider the code amendment for first reading and also take final action on CEQA and the shelter project either on September 3rd or October 1st, depending on what action the Airport Land Use Commission takes. With that, staff recommends that the Planning Commission recommend the City Council adopt a resolution adopting the initial study mitigated negative declaration, including the mitigation monitoring reporting program for the proposed project at 3175 Airway, and also recommend that the City Council approve Code Amendment 19-01 to introduce an ordinance in order to amend Table 1330 of Chapter 4 of the Citywide Land Use Matrix and Article 18, Emergency Shelters of Chapter 9, Special Land Use Regulations of Title 13 of the Costa Mesa Municipal Code. Mr. Martin and I are happy to answer any questions you might have at this time.
Thank you, Mr. Curtis. Commissioners, any questions? Commissioner Navarro-Woods.
I just had a couple of operational questions about the shelter. Is it for just adults 18 and over?
Yes, that's correct.
Okay. And I think I read something that there could be flexible spaces so that if someone identified as non-binary didn't fit neatly into one of the gender categories, they would have the city might be able to accommodate that.
That's correct. Best practices in shelter do call for some flex spaces for purposes like that, and the city would look to incorporate that into our design.
Would there be an opportunity to keep couples together?
Our model is not to keep couples together. However, best practices in local shelters show that couples are able to stay within the shelter, attend services together while sleeping separately. However, they are allowed to keep their belongings that are exterior to the facility in storage units that are close to each other. So that's what we'll be doing to help couples feel comfortable in the shelter.
Okay.
They will not be able to sleep together in the same dorm.
Okay. And in other dorms, how many people would typically be in a dorm?
I mean, it really depends on the size. Our shelter right now is 450 beds. So in our temporary shelter, we have 18 women as the makeup of women, and the rest fall under men. That kind of goes in line with the point-in-time count in Orange County, and that's what we've seen some success with. Those numbers are different than when we first started. We had 12 beds for women when we first started, and we saw that women were more willing to accept shelter or to try it. So we had portable walls, so we were able to move those walls in our dormitory to accommodate 6 additional women.
Oh, okay. All right, thank you.
Okay, anyone else? Commissioner Zick, and then, I'm sorry, Commissioner Russell, and then Commissioner Zick.
Okay, just in this new shelter, will you have the ability to be flexible and change how many beds you have for women versus men as the need comes up?
Yes, Commissioner Russell. So the dormitory spaces are open spaces where beds can be either single beds or bunk beds. So in our current shelter, we've been able to change our layout without changing walls by adding bunk beds on top of single beds, and we'll be able to do that at the permanent shelter as well. As I mentioned, we will have some flex spaces as well for circumstances that should arise, and we'll look to use those spaces as well in a similar fashion.
All right, thank you.
Commissioner Zick.
Thank you, sir. On page 28, this map that shows the zoning, the areas that are currently PDI permitted by right, is that existing today without the code amendment?
Sorry. Page 28.
It's a staff handwritten, page 28.
Oh, the staff report, sorry. Sorry about that. I think I'm dyslexic. I went to page 18. So can you repeat the question again? Is the question?
The first part is, for the PDI permitted by right, are those currently existing by right locations, or is this what is proposed as part of the code amendment?
That is currently existing by right.
And the MP permitted by CUP, is that what is new?
That would be what's new, correct.
And why aren't, so in the, I'll call it the Measure X zone, why aren't all of those proposed as permitted by right?
We, through this project, we're not proposing to expand the permitted by right area. We'd like to be able to limit that to the area that was determined by the city to meet the minimal requirements of SB2. Therefore, the other zoned areas in that area, so the zoning, the areas that are shown in purple, or the violet purple, are PDI zone today. So that's the existing zone, and that's where they're allowed by right. The MP zone, or the more purple colored areas, those are the areas where we're proposing to allow it through a CUP, but we're not proposing to change the zoning in any of those properties other than to allow a shelter through the approval of a conditional use permit in those areas.
Okay, so still looking at just the Measure X zone, help me understand why the PDI, how they were determined? Was it, let me see, are they all currently zoned as PDI? And so by definition, you picked them?
Yes.
Okay. Now, over in the airport area, why is the Executive Guild not included as a permitted by CUP?
It is not zoned MP. So we're proposing to zone the MP zone area to allow it through a CUP.
Got it. Okay, that answers that. Thank you. Not in any particular order, but on handwritten page 8, there's a in the third paragraph down, there's an explanation that talks about a shuttle bus to and from the shelter. That's referring to the new shelter?
It is in the report referring to the new shelter, but it's also the system that we're currently using for our temporary shelter as well.
Okay, so I recognize then the shelter is one node of that trip. What's the other node?
Sure. So the shelter is the destination. When clients leave the shelter, currently there are 3 places where they can go. Those are scheduled stops that take place 6 times a day. Those are at the Crossings Church, SOS, and on the weekends that includes City Hall as well.
And the only way they'll be able to leave the shelter is by getting on this bus and going to one of those 3 drop-offs.
So they have to leave by transportation. As I mentioned earlier, we do have folks who use Yellow Cab or who use a ride-share service, but the majority of the clients at the shelter use the transportation-based shuttle service.
Can a friend come pick them up at the shelter?
Only if it's scheduled through the security. I think it's important to note that some clients at the shelter go to work, some go to school, and that there are varying levels of acuity based upon what their needs are for their housing plan. Some of them only need several weeks to get a down payment. So it really just depends on the level of the person and how fast they can move through their housing plan to really know how long they're going to be using the transportation-based service.
Okay. On page 5, where it is talking under bullet point 2, this this patrolling activity, who's actually doing the patrolling?
The patrol includes a security guard that's hired by Mercy House, our professional shelter operator, as well as a Mercy House staff member.
And so from an enforcement standpoint, if this patrol officer sees homeless individuals or suspected homeless individuals congregating, what is the enforcement action?
Sure. So the security guards don't do enforcement to homeless individuals that they might experience within that half-a-mile radius. However, they are handing out homeless resource information so that those individuals can meet with our outreach workers. They're given times throughout the week where there are what we call in-reach and outreach hours so that they can get on the list to become a shelter client. If there's something illegal that's happening or that's a threat, they're either calling the Costa Mesa Police Department or our code enforcement officers, depending if it's public or private property.
And what's the frequency of these patrols?
Every 2 hours. So they mirror when the shuttle stop is not in service, the half-mile roving patrol is in the opposite time as that.
Okay. Another question I had that kind of goes back to this zoning. Do we anticipate obviously non-city organizations to establish emergency shelters in any of these properties?
Our concern and the reason we required a conditional use permit in this process was in case that happened. We do not think it's likely that an agency will, but an agency could potentially do so. There are certainly religious affiliated shelters in numerous places that you've probably seen. That would require conditional use permits, so you'd have regulatory authority whether or not to grant that approval.
Now that would be, of course, if they only chose a property that was currently an MP zone. If they picked one of the PDI, they could establish emergency shelters by right.
That's correct.
And if it made good business sense, if there was a source of revenue for this, we would probably should expect there'd be a lot of this kind of activity.
Potentially.
Okay. And if that were the case, do you see a situation where there'd be a concern about the city's shelter competing from the standpoint of the Article 18 I'll call them conditions, not all being applicable to the city, yet being applicable to a for-profit or a not-for-profit organization?
The circumstances as are proposed would make it advantageous for the city over a non-city shelter because of the applicability of a number of the conditions. So we do not think that would be a case. Also, the intent of the shelter is to meet the city's needs as far as sheltering its homeless. So our thought is that there may not be a call. I'm sure other cities would love to put shelters in cities that aren't their own. And that's part of the reason that we want to require a conditional use permit for this. If it's in a by right area, it's already allowed under SB2, but cities aren't really allowed to put those in other cities, so it would be not an issue.
Okay. So this Article 18, would it be fair to say that we're establishing it in total, and then we're exempting the city from conditions 1, 2, 4, and 8, and we're really not anticipating anybody else opening a shelter that would be subject to all these conditions?
That's true.
But if they were to want to establish a shelter, then we get them with conditions 1, 2, 4, and 8.
We get them with conditions 1, 2, 4, and 8, and if they're not in the PDI zone, we get them with a conditional use permit. I don't mean get them in the bad sense, but they're required to meet those.
I totally understand. Okay. What is the number of full-time equivalent employees dedicated to operating the shelter? I say full-time equivalent just in case you've got part-time people. I want to make sure they're counted.
Thank you, Commissioner Zick. So I'll speak in terms of, I'll separate it between full-time and part-time. The Neighborhood Improvement Division oversees everything related to homeless. There is a neighborhood improvement manager. There are 2 community outreach workers who are solely working inside of the shelter. They're the case managers for the 50 clients. They're on a ratio of 1 to 25, 1 caseworker to 25 shelter clients. That's a national best practice. Outside of the shelter, we have outreach workers who work with homeless individuals who either are not interested in shelter or are not eligible for shelter, and we have 4 part-time equivalents, each working between 20 and 30 hours a week, 7 days a week. We also have a homeless consultant, Ms. Muriel Ullman, who has helped with all the policies and procedures and really getting the Network for Homeless Solutions moving forward so we could get to this part. So that's the makeup of the Neighborhood Improvement Division.
So is that 8 or 9 people as I counted it?
Yes, essentially.
Okay. And then does the city pay Mercy House for their operation activities?
Yes, the city pays approximately $1.5 million annually to Mercy House to operate the shelter. They are taking care of the day-to-day, the security, the transportation, the meals, the programming outside of the physical case management that takes place by those staff that I mentioned.
Okay. And then I have just one more question, but I'd sort of introduce it this way. I remember being on the 3R committee, and many of the 501c3s would come forward when it was CDBG grant time. And one of the questions that I always like to ask them is, what's your goal? Many of them would tell me their goal was to expand the number of people that they serviced. It's an admirable goal, but it wasn't the answer I was interested in hearing. I was interested in hearing them talk about solving the problem. In other words, putting themselves out of business. So my question to you is, what set of conditions or circumstances do you see somewhere out in the future where the city shuts this center down and sells the building?
Well, homelessness is a national epidemic. It's not just an Orange County or Costa Mesa issue. Everyone needs to do their fair share, and the fair share means different things to different people, but certainly as a city, I think we've taken a lead on doing our fair share since 2013 when we established Network for Homeless Solutions. The City Council took really brave action this year to end the Orange County Catholic Worker lawsuit. They literally have spent $10 million this year of taxpayer dollars to work towards ending homelessness in Costa Mesa. We have done our fair share. But it takes a much larger group of people to end a national epidemic. So certainly from a county level to our neighboring cities to a state and even to the federal level, there are many things that need to be done. Funding for homelessness needs to increase. Collaboration between the agencies to break down silos and to really connect the continuums of care. It needs to be something that continues to focus. Again, Costa Mesa, I believe, is a leader in this. It's something that we've taken huge steps on in 2019, more so than any other city in the county. We certainly have more to do, but we do believe that we're taking proactive steps in the right direction.
And how do you see the relationship between I'll call it the obligation of the charity networks and municipal networks in terms of dealing with this condition? Do you see it as a government responsibility, a charity responsibility, a partnership? How do you see that?
I think it's a humanistic responsibility, to be completely honest with you. I think we can achieve more with all the parties working together. Again, I think funding is an issue that everyone sees as a challenge, and I think with all of those nonprofits and government agencies and private entities working together, we can help to solve that problem.
Those are great answers. Thank you very much. Thank you, Mr. Chair.
Thank you. Vice Chair Harlan. Oh, okay. Anyone else? Okay, I have a couple. So we have no SB2 shelters in Costa Mesa presently.
That's correct.
Is there any indication that we're going to have some soon?
We have heard nothing, no.
Okay. So the PDI zone isn't being taken advantage of?
As I indicated, when we were looking for a site, we found a number of sites that were either for lease or for sale in that zone, and most of them are in condominium projects that have CC&Rs that prohibit the use.
Okay. So, an ALUC question. It seems their principal concern is that the shelter is located within its 65 CNEL noise contour. Is that correct?
That's correct.
And you just said that without any attenuation, we're at roughly 45. Are they aware of that?
We just found out today.
Okay.
We will make them aware of it when we meet with them.
This
They
evening,
were
we
aware,
found
though, that we were requiring this to be attenuated to 45 CNEL.
Okay. So do you imagine that they'll have a problem if that's the critical issue?
When we met with their staff in advance of them preparing their staff report, they already were aware that we were going to sound attenuate to 45 CNEL, and they still recommended it be found inconsistent. And the reason is because they consider the use to be a noise, a sensitive institutional use, noise-sensitive institutional use. They've made decisions in the past on uses similar to like a congregate care facility wanting to come in areas like this, not necessarily in Costa Mesa, and found that those were inconsistent because they're comparing this use to uses like that. We don't think that's an appropriate comparison because those are facilities where folks are there pretty much around the clock, often for years at a time. Right. As I said, we believe this is much closer in operations to an extended stay hotel or a hotel. Therefore, we don't believe the duration or even the daily impact of the noise is dissimilar to other folks that are already in the area.
Okay. And then, so is part of the settlement agreement, and it is Judge Carter's order that we have to provide shelter for 60% of our point-in-time homeless count. That's correct.
That's correct. It was the 2017 point in time.
Yeah.
Okay. And so we do that point-in-time count once a year?
Every 2 years.
Every 2 years? Okay. So here's my concern. Well, I guess I'll share it later. My concern is that around the time that point-in-time count's going to occur, all of a sudden, magically, the homeless population from other jurisdictions are going to wind up in Costa Mesa. And I'm wondering how we safeguard against that.
I can speak to the most recent point-in-time count did take place in January of 2019. This was before the Costa Mesa Bridge Shelter opened, and Costa Mesa's number, I believe, was 193 unsheltered homeless individuals. What we have seen, what you may have seen when the shelter opened, was that there was a natural decrease and homeless individuals who are on the streets of Costa Mesa. Again, that number was before the shelter was in place, so that automatically, technically, could be bringing that number down by 50 just with the operation in place.
Do the members of the city council and perhaps Chief Sharpneck, and I've only heard this anecdotally, but the tendency is for law enforcement agencies in other jurisdictions to bring their problem here. Are there conversations that go on consistently say don't do that?
If you checked my email today, you'd see an email to acting police chief with reminders to our local agency colleagues in police and fire. We have specific procedures how you can enter into our facility, and it has to be vetted through the police department and through community outreach. There's no other way. No other agency can try to drop off or call dispatch. So it's an education piece, to be honest, to remind the rank and file employees in other cities to
But that would
follow
not
those
be true of an
procedures.
SB2 shelter.
No.
All right. Anyone else? Then I'll open this for public comment. Anybody wishing to speak on this item, please come forward. This is actually a public hearing, so I'll open the public hearing and... Yes, sir.
How are you? How are you all? Wade Strauss. My family owns the building directly across the street from the planned facility on McCormick Avenue. I do want to acknowledge that, the city's going to extraordinary lengths to take care of its homeless population. I do also want to acknowledge that, that the plan does go to quite lengths as well to help to minimize the impact of a facility in a location like this. Obviously, our personal concerns are going to be both property value as well as the safety and well-being of the tenants in the building, of our tenants in the building. And, so I guess I read through a lot of the documents, but I guess what I do want to just kind of bring up to you all and would love to hear back is, I really would like to know what the city's commitment is to making sure that you're going to follow through with the communication in terms of how you plan on instituting this and following through and maintaining this plan and implementing the plan. Number one of the things I noticed is that the budget is about $1.5 million. I did look through the operation plan, the number of employees, the shuttle. Are they going to be able to follow through with that? Number two, the language doesn't seem consistent between what's in the city's documentation and what's in the operation plan in terms of transportation. And in the city document, it says we need to, that the residents are only going to be able to enter via the shuttle, yet the operation plan seems to suggest that Ubers and pickups are also going to be permitted. So I do want to make sure that communication is clear. And then finally, it appears to me the amended language for the code does not appear to allow for this proposed shelter in regards to size, number of beds, and the hours of operation. And so I just want to encourage you to take a closer look at that. And if you do have any comments regarding it, I'd appreciate that as well.
Thank you, sir. So anyone else wish to speak to this item? Okay, seeing none, I'll close public comment. So Mr. Martin or Mr. Curtis, with respect to Mr. Strauss's questions, how do we assure operational standard? Do we have a process by which we will audit or monitor the performance of Mercy House is, I guess, the question. And then the clarification on transportation, I'm sorry. Entering via shuttle only or also ride sharing, and I think I heard Mr. Martin say it could also be ride sharing, or maybe that's pickup. Anyway, maybe if you could clarify those things for me.
Sure. So from an audit perspective, part of the reason why we're doing our hybrid model of incorporating city staff in the shelter with Mercy House is to be those eyes and ears. What we saw leading up to the opening of our shelter were agencies that were a little bit disconnected from how their shelters were running, and maybe where there were some gaps in service or areas that needed to be brought up to a higher standard. And we wanted to be able to provide those eyes and ears on site so that we could help to avoid that. What we also saw was that case management seemed to be poor from a provider standpoint. So we knew that we had already been providing that at a high quality, and we wanted to continue that. So from an audit perspective, we're on site. There's a code enforcement officer. There's going to be a desk for a police officer as a working station from our community policing unit when they're available. So the neighborhood improvement manager will be housed out of this facility. So the eyes and ears are something that our city council and staff believed are really important. From a communications standpoint, when we started this whole process, we did extensive outreach, not only to the community of residents, but also to businesses that were located adjacent to this property. We knocked on doors, we sent mailers, we had separate meetings. We'll continue to do that again as this process continues to move forward, hopefully after this evening. But our good neighbor policy that you heard me mention includes continued outreach. For example, this past weekend, we had a group of city staff as well as Mercy House staff who went out within a half-mile radius of the shelter to give out surveys to solicit feedback from residents. And 2 weeks ago, they did that with the businesses in the area. So that will continue as a form of good neighbor outreach. In terms of following through with the plan, we're doing that now. As I mentioned, we're looking to transfer the operation from the 1885 Anaheim Avenue property to the 3175 Airway property. So we're learning a lot of things now. We're adding to our operation plan to come up with those unforeseen circumstances. But what we've said from the beginning is that we have a year to figure it out before we even look to attempt at approaching the 3175 Airway Avenue facility. Our goal is to minimize any impacts to any neighborhood where a shelter is in the city. Our goal is to have someone drive by and not even know that it's the city's bridge shelter. Our model follows a shelter in Anaheim called Bridges at Kramer Way, which if you drove down the street, you would never know it was a homeless shelter. And that's exactly what we're looking to mirror. In regards to transportation, the main means of transportation in and out of the shelter is a shuttle. There will be exceptions when someone may have missed the shuttle and has to get to work, or when someone works past when the last shuttle returns, or if someone needs to go to an appointment, maybe that's not in close proximity to a bus route. So we do allow that. We are a low barrier shelter. That's part of our settlement agreement. We have to be providing resources and available means for people to transport, whether it's on our shuttle or not. That is our main means of transportation for 95% of the clients, but there is a window where there are some alternate means of transportation that are required.
Okay, thank you. And then just one other question. Is there a protocol that we have in place that provides the surrounding community channels to communicate with us about concerns, questions on an ongoing basis?
Absolutely. We just created a new homeless resource guide for businesses and residents. That's what the team was handing out to the residents and the businesses within that half-mile radius. We'll continue to do that should we move to the 3175 Airway property. We'll also hand out business cards for the staff who are on site for both Mercy House and the city, similar to what we did by the current temporary shelter.
Okay, terrific. Commissioners, any other questions? Commissioner Navarro-Woods.
Will there be an opportunity to do some preliminary outreach before establishing yourself at 3175 so that we can kind of encompass local business owner concerns and maybe adapt operational guidelines when appropriate?
Absolutely. Part of the Mercy House contract requires them to come up with the transition plan along with the city for the move from the temporary shelter to the permanent shelter, which includes that outreach.
And then is the budget for the operating costs, is it appropriated in the long term, or does it have to be approved annually by City Council?
Our initial contract is a 2-year contract with 3 one-year renewals for Mercy House. It's locked in for those first 2 years, so it's an automatic renewal. We certainly can make amendments if there's a need for something like that, but it is locked in for a minimum of 2 years.
Okay, thanks.
Okay. So I will close the public hearing if we haven't already done that. I can't remember if I did that or not, but I just did it again. I have a motion to recommend the city council adopt a resolution to adopt the initial study mitigated negative declaration, including the mitigation monitoring report and program for the proposed project at 3175 Airway Avenue. Recommend that the city council approve code amendment CO-19-01 to introduce ordinance 19, whatever it's going to be, in order to amend table 13-30 of chapter 4, citywide land use matrix, and article 18, emergency shelters, of Chapter 9, Special Land Use Regulations of Title 13, Planning, Zoning, and Development of the Costa Mesa Municipal Code. And if there is a second on that, which there was, Vice Chair Harlan and I will have comments. But I'll let other commissioners go first. Vice Chair, if you'd like.
Thank you. The only comment I really want to make is I wanted to commend the City Council for its leadership and commitment and perseverance in addressing our homelessness issue. And I think that applies equally to staff. This effort has required a lot of collaboration, coordination, and some creative thinking. And I think what we have in our temporary shelter seems to be working well. And I'm glad to see that the lessons learned there will be applied, hopefully, to a permanent shelter. And so I proudly support this motion, and I'll leave it to the other commissioners for their comments.
Any others? I just want to say that a couple of things, and I echo everything that Vice Chair Harlan said about terms of the council having the courage to kind of expend quite a bit of financial resources to make this happen, staff time, creativity to find a place to kind of get past the lawsuit and begin dealing with our homeless issue. So congratulations to them. I'm proud to have this vote and support it. I will note that I agree completely with Mr. Martin that the city does its fair share, beyond its fair share, I think. One day, I would love to see Mr. Curtis's signature on a City of Costa Mesa letterhead to the City of Irvine, commenting on the City of Irvine's ISMND for their shelter. I don't know that that's going to happen soon, but I just want to make it very clear to the elected leaders in Sacramento who represent this city and to certain judicial officers that Costa Mesa has stepped up to the plate, and I would strongly suggest that they start insisting that other cities in the County of Orange step up and do their part. We've done our part. And I'm happy to support this. I think it's great. But don't come back to this punch bowl anymore. We're doing a good job. So go somewhere else. And with that, we'll call for the vote.
Motion carried 5-0 with Commissioner Colbert and Commissioner Torje absent.
Thank you. And is that an appealable decision, or that just goes to the council? That's what I thought.
It will go to City Council.
Okay, very good. Development Services report?
Only a reminder again, Commissioner Navarro-Woods already mentioned this, but we have a study session tomorrow night to discuss small cells. It's at 5 o'clock?
Yes.
5 o'clock in the council chambers.
Thank
Otherwise,
you.
nothing else, sir.
Thank you, Mr. Curtis. Mr. Mejia?
No reports tonight.
Okay, thank you. City Attorney, Mr. Preziosi?
No reports.
Okay, thank you. That means we'll stand in adjournment to our regularly scheduled meeting of August 26th. Good night.
Officially meet you. Yeah, congrats. So I'll see you September, possibly October then.
Yeah, we'll know Thursday.
Oh, okay, so you'll, I was gonna say, do you need me present at?